Okay, this is the videotape deposition in the Chancery Court of DeSoto County, Mississippi, Arbors of Wedgewood Homeowners Association versus Thomas Tita Noir and Sally Famusa. This is the 30B6 videotape deposition of the plaintiff, Arbors of Wedgewood Homeowners Association, pursuant to notice and court order. My name is Ben Taylor, and I'm filming this on a GoPro Hero 9 Black, and it is 8:59 a.m. If you would go ahead and swear the witness.
Would you raise your right hand then? Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, ma'am.
Thank you.
Good morning.
Good morning.
I've introduced myself before. My name is Ben Taylor. I'm the attorney representing the defendants in this case. Could you state your name for the record?
Christie Anthony.
Okay. And Ms. Anthony, you're here, and I'm assuming to be designated as the representative for the Arbors of Wedgewood Homeowners Association. Is that correct?
That's correct.
Okay. And I'm going to hand you a copy of the notice for this deposition. Have you seen that document before?
Yes, I believe so.
Let's go ahead and mark that as the first exhibit.
Hand it to her so she can look
Okay.
at it.
Exhibit 1.
Mm-hmm.
Ms. Anthony, where are you currently employed?
Keith Collins Company,
And what do you do for Keith Collins Company?
Association Manager.
And how long have you had that job?
January 4th, 2022.
And is that how long you've been at Keith Collins?
That's correct.
Okay. And what did you do prior to Keith Collins?
I was a stay-at-home mom for 16 years.
Okay. And then what about part of that?
I was in high school.
In high school?
Yeah.
Okay, okay. So this is, I guess, this is your first full-time job?
Basically, yes.
Okay. And how did you go about becoming an association manager at Keith Collins?
I'm friends with another association manager there that brought me on board.
Okay.
Introduced me
That
to
brought
Keith.
me what? You're gonna
Brought me on
speak-
board. Introduced me to Keith. And
You're
my
gonna have to
kids,
speak very
my kids
distinctly.
were grown, so I wanted to get back into the world.
Okay. And who's the person that you knew that got you the job?
Teresa.
Teresa.
How do you say? I don't know how to say her name.
Bowling,
Bowling.
B-O-E-H-L-I-N-G.
Yes.
B-O-E-H-L-I-N-G.
Okay. And is Miss Bowling, is she also an association manager?
She is.
And what does an association manager do?
We are directed by the board. We do violations, collections, just whatever the board instructs us to do.
Okay. And Keith Collins Company, it's an association management company, right?
That's correct.
Okay. And I was looking at its website, and it talks about, I guess it has a section, frequently asked questions.
Okay.
Okay,
I'll hand you
hold
that.
on a second. Hold on. I'm gonna object to any line of questioning about Keith Collins. That was not something that was designated in the 30B6. and I don't think it's relevant.
Okay.
Having said that, you can answer the question if you can.
Okay. You work at Keith Collins, and you've been designated as the representative for the Arbors of Wedgewood Homeowners Association, right?
Object to the form of the question.
Okay. Let's go through this notice. That's exhibit one.
Okay.
We'll skip this for right now. On the second page, it goes through and it has, it looks like 10 areas of inquiry that we're going to go over. Are you familiar with those? Have you looked through those?
I mean,
No.
no.
Okay, well then let's go through them then. The first one is all non-privileged information regarding all communications and contact between the Arbors of Wedgewood Homeowners Association, Inc. and/or Thomas Tita Noir and/or Sally Famusa and/or any other entity related to the transactions involved in this lawsuit. Do you see that?
I do.
Now, is Keith Collins any other entity that's related to the transactions involved in this lawsuit?
Answer the question. You can answer.
I don't really understand what you're asking me.
Well, I guess I'm wanting to know why you're the person that was designated by this homeowners association to come and answer questions about this lawsuit.
Because I'm the association manager for this neighborhood.
For this particular neighborhood, okay.
Right.
Okay. And going back to the webpage, one of the questions on the webpage, it says, what is a management company and what does it do? And it says a management company is contracted by the board of directors to provide services including collection of assessments, supervision of subcontractors, obtaining bids for subcontracted services, providing financial statements and collection reports, as well as a general clearinghouse for problem solving.
Same objection.
The management company reports directly to the board, and all decisions are made by a majority vote of the board of directors. Is that accurate?
It is.
Okay. And it goes on to say, the manager has two primary responsibilities, to carry out policies set by the board and to manage the association's daily operations. Is that accurate?
That's accurate.
So part of what you do is you collect assessments for the association.
That's correct.
What are assessments?
Same objection. You can answer.
We collect their monthly due, their yearly dues. They have a special assessment, we collect that. Just some people are fined. Just anything involving collections.
Okay. So the dues, I guess what you're talking about are the yearly.
The yearly annual.
Homeowners Association dues.
That's correct.
And then you also said special assessments. What are those?
If they have a project that needs to be completed and each homeowner has to pay a certain amount of money, the HOA has to collect in order to have this project completed.
Okay. Now, does Keith Collins, do you use a software program to help you do this?
Objection, relevance. You can answer if you want, if you know.
We use Caliber.
Okay. And is that a proprietary software or?
You don't know?
I don't know.
So in other words, is it something that just Keith Collins has, or is this something that other property association management companies
Same
have?
objection, outside the scope of the notice and irrelevant to the facts in this lawsuit.
Let me back
Answer
up
if you
then.
know.
Do you use this software program in your day-to-day business of collecting assessments?
Yes.
Okay.
Same objection.
Is it web-based or is it, I guess, on your computer?
hold on a second. Let me just make a continuing objection so I don't have to
That's-
object to every question, okay?
That's fine, but just state whatever your objection is.
I'm going to. I just want to make sure that everybody understands before I go any further. I mean, I'll make the objection every time you ask a question if you want, but I'm trying to not do that. I'm going to object to any testimony about how Keith Collins operates. This is outside the scope of this deposition notice. It's completely irrelevant to this complaint. This complaint is based on a judgment that was taken against the defendants and doesn't have anything, and Keith Collins, all this information about Keith Collins doesn't have anything to do with that. So, that judgment is final, and the case is proceeded based on that judgment.
Okay.
And in order to prevent having to make an objection to every question, irrelevant question that's asked, that's a continuing education, continuing objection to anything about Keith Collins or how it operates, its software, and all that kind of stuff.
Okay. Let's do this. Let's go ahead and mark this as the next exhibit.
Objection. It's irrelevant. I've already said it. I'm gonna object to exhibits. I gotta do that individually, but,
Yeah.
and also as
Wait
to
a minute, wait a minute.
authentication. Sorry.
And also what?
As to authentication.
Okay, I gotta hang on now, let me do my job.
All right, let's see, exhibit 1 was the notice.
Yes, exhibit 2 is the Keith Collins information.
For now.
Okay. Looking at exhibit number 2, that first page, at the bottom, it says the manager is trained to deal with conflict. Is that something you are trained to do?
Yes.
Okay. And what kind of training have you received in that regard?
I mean, I don't understand your question.
Well, it says that the manager is trained to deal with conflict, and you said that you were trained to deal with conflict. And my question is, what training have you received?
I mean, I shadowed a senior manager when I started to work at Keith Collins.
And who was that?
Joyce Spiaka.
Joyce.
Spiaka, S-P-E, S-P, I should know this.
Spiaka, S-P-E-I-C-H-A. I think. I don't have my phone or I could look it up.
Can I look at,
Do you mind if she
Sure.
looks up how to spell it?
don't tell her I didn't know how to spell S-P-I-E-C-H-A.
Now, I know you testified you're the association manager for the Arbors of Wedgewood Homeowners Association. How many other associations are you the association manager for?
34, I believe.
And how are those assigned, or how do you receive those clients?
Keith gives them to us.
Okay. And I guess my question is it more by geographic area or by the size of the homeowners association? What?
He tries to, but not really. I'm in Olive Branch, Hernando, downtown, and Lakeland.
Besides the Arbors of Wedgewood, what other homeowners associations do you manage in DeSoto County?
I can't sit here and name all of them, honestly. Like I said, I have about 34 to 36, so.
Okay. And have you always had that many?
Around. I think I started with about 30, so.
And do you have anyone who works with you?
I do.
And who are they?
Morgan. Anthony.
Morgan Anthony?
Mm-hmm. Yes.
And is she related to you?
She is.
Who?
She's my daughter.
Your daughter. Okay. And how old is she?
Objection,
What?
relevance.
Well, you said that she helps you or that she works for Keith Collins, right?
She does.
Okay.
But I don't really think her age matters.
Okay. Well, how long has she worked at Keith Collins?
2 years.
Okay, 2 years. And what does she do?
She is my assistant, and she also has about 15 of her own properties.
And as your assistant, what are her job duties?
She assists
Objection,
me.
relevance.
She assists, just whatever I need her to do, she assists me.
Okay. Do you have anyone else that works with you?
No.
Okay.
Not directly with me, no.
Okay. How long has Keith Collins managed the Arbors of Wedgewood?
I'm not sure.
Objection, relevance.
Do you have records that would reflect that?
Not with me, no.
Okay. Where are they?
They're in Caliber in our system.
Okay. And I guess now is as good a time as any to go back to the 30B6 notice. I asked that you bring documents with you to the deposition today. Did you bring anything with you
I did.
in response?
Yes.
Okay. Well, let's go ahead and
Okay, well, let me,
See what you have.
what are you which part of your, notice are you referring to right now? Because I've got some objections that I need to raise, if that's where we're going.
okay. Well, the first thing that I asked that you bring with you is the names and addresses of all known witnesses to the matter at issue or persons having knowledge of any of the facts of the matter, and the names and addresses of all persons who might know of witnesses to the matter at issue or persons having knowledge of any of the facts of the matter.
Okay. General 30B6 notices do not permit you to do a request for production except as pursuant to Rule 30B5, which is included beginning on page 3. Defendants demand that 30B6 designee bring names and addresses of all known witnesses to the matter at issue or persons having knowledge of the facts of the matter, and the names and addresses of the persons who might know witnesses to the matter at issue or persons having knowledge of any of the facts of the matter is improper under the Rule 30B6, which requires a topic to be reasonably particular, and any and all is not reasonably particular. Defendants demand that the deponent bring copies of all records, etc., demonstrative evidence, or anything related in any way to this lawsuit is inconsistent with the 30B6 designation, and it seeks to enter the attorney-client privilege. In addition, the request is unreasonably duplicative in that defendant's counsel has already been provided with every scrap of evidence that will be presented in this matter. That objection is raised as to the language of the notice on page 1, beginning in the bottom of the page, going over to page 2 to the end of the paragraph. So those documents have not been provided today and will not be provided today.
So that answers that. So you didn't bring any witnesses, any names of any witnesses or anyone with you?
No.
Okay. And were you instructed not to do that?
No.
Okay. The next part is the deponent is to bring copies of all records of Thomas Tita and/or Sally Famusa, as well as any other documents, photographs, charts, diagrams, recordings, digital media, or any other matter or thing related to the cause, including but not limited to any item of demonstrative evidence to be used at trial or related in any way to this lawsuit, including but not limited to any diary, calendar, journal, or other writing kept by or in the possession of the deponent. Do you have
So-
any of those documents?
Oh, hold on. I just made an objection to that defendants demand that deponent is to bring copies of all records, etc., demonstrative evidence that Mr. Taylor just read is inconsistent with the 30B6 designation, not required by the rule, and it seeks to invade the attorney-client privilege. Furthermore, it is unreasonably duplicative in that defendant's counsel has already been provided with every scrap of evidence that will be presented in this matter. Now, again, on the following pages, there is a specific 30B5 designation or 30B5 request to which we have a general objection, but we have specific and individual objections there, which will include what you've asked for on pages 1 and 2, some of which is included in your 30B5 designation.
And so I'm clear, and to save time, are they the same objections or?
Not necessarily, no.
Okay.
I mean, some of the stuff that you've requested in 30B5, I mean, I've got documents here that will be provided when you get to that, and some specific objections to the requests that you put in. And I'm gonna say this too, I probably already should have said it. This order sets a 30B6 deposition. It doesn't say anything about production of documents, 30B5, or anything like that. And I've got a copy of the order here. So I think part of the problem with this is the order only provides for a 30B6 deposition. It doesn't provide for requests for productions. Having said that, in an effort to try and cooperate, we have brought some of the documents that you requested.
Did you say you did have the administrative order?
Yeah. This
Would
order
you-
right here.
Sure. Would you mind giving it to the witness, and we'll make that a exhibit?
Okay.
This is gonna be exhibit 3. That's the order.
Miss Anthony, have you ever seen that document before?
I don't think so, no.
On the right-hand side of the document, there is interlineated some handwritten words, and I don't know if you can make that out or not. Can you read that? Do you see what that says?
Some of the words I can't.
Okay.
Are you waiting on me?
Yes, ma'am. Which
Oh,
ones
I
can you
didn't
make out?
realize.
No, that's
I
okay.
didn't realize you were asking me.
I'm sorry, I didn't know we were waiting on you
I
either.
didn't, yeah.
Which ones can you make out?
With document, maybe? Production, except one deposition, 30B6092724.
So you can make that out. It says document production.
Production, yeah.
Okay.
From the-
So, but you didn't bring any documents with you here today?
No, that's not true. We already told you, we brought some documents pursuant to your 30B5 list, but
Okay.
we're not bringing them pursuant to your demands on first paragraph, beginning on page 1 and 2 of your deposition notice, because that's not what the court ordered, and it's not what is anticipated by a 30B6 designation deposition.
What documents did you bring?
I brought the ledger. I brought violation letters. And do you have my folder?
Mhm.
I can see what else I printed. And I brought
That's your file, isn't it?
my file. Mhm.
Yeah.
And I brought legal invoices from everything that I have from 2018, I believe.
Okay. Do you mind if I see that?
Hold on. That's her, I've got you a copy, and I have designated it as response to your 30B5 request number 13, which is your request for a copy of the entire transaction file concerning the charges for fees or assessments, coding, submission of bills or invoice, contacts or conversations, pleadings and or any other document or documentations related to Thomas in the deponent's possession. That I just handed you is that response to 13, and that also covers a response to your designation on your request on 20, 21, 22, 23, everything that's relevant in 2027.
Everything that's relevant in 2027.
I'm sorry, in 27, number 27. Mr. Taylor included a list of 30 requests for production of documents pursuant to Rule 30B5. We have objected to that request because the order allowing this deposition is a 30B6. It doesn't reference or permit an expansion of that deposition to include a request for production pursuant to 30B5. However, because we're trying to get this thing done and because we're trying to cooperate, in spite of the fact that Mr. Taylor has been on this case since
I'm going to object to
January of
speaking
2022.
objection. The amount of time that's transpired doesn't matter.
Well, it does matter, and I'm going to finish my objection. No discovery requests were propounded. So, again, in an attempt to be fully transparent with regard to the issues involved in this case, we have provided the documents that Mr. Taylor has asked for to the extent that we have them over without waiving our objection. And
Okay.
that's paragraph 13, 20, 21, 22, 23, and 27 are all covered by what we have by that file I just handed you. And I've labeled it paragraph 13.
So I'm clear, counsel. Do you need to be sworn? Are you going to be designated to testify in this deposition? Or,
You know I'm not going to answer that question.
well, I don't know. You're saying a lot, so. Miss Anthony, the file that you just had, could you get that back? You said it was your file, right? Do you know if what's in that file is the same that's in this folder that was just handed to me?
No, I haven't seen what's in that file.
Okay.
This is what I brought.
Well, let's do this. The file that was just handed to me and represented by counsel as being a response to request 13, let's mark that as the next exhibit.
So that's gonna be 4.
Yes, that will be 4.
5, gold,
Go, ma'am.
13. Now, if you want to, Ben, I'm happy for you to compare these two files if you don't believe that they're the same. And we'll just take a break and let him do that. Is that okay with you?
I'm not ready to take a break yet. I want to go ahead and mark this one as well.
No, we're not
As
gonna
the
mark
next
that one as
exhibit.
well. We're not gonna.
We're referencing it and.
No,
I have
I've just
it.
told you that all of the documents in Christie's file have been copied and provided to you. Now, if you don't believe me when I tell you that those documents are exactly the same, then we can stop and you can go through it and make sure they're the same. But we're not gonna we're not gonna duplicate this. That's not necessary. You are welcome to compare those files.
This will be marked as Exhibit 5.
Yes, ma'am.
Okay, well, let me go make a copy of it, so I have a copy of all the exhibits in the file, in the case. Let me give it to me, and I'll go make a copy of it.
Well, okay, we'll do that when we take a break. I'm not ready to take a break yet.
Well, I'm not, it really doesn't matter. I want to make sure that we have a copy of the exhibit.
Rasmussen, this is my deposition. I'm going to conduct it the way that I want to conduct it.
Well,
I'm not ready to take a break yet. When we get done and we get to that point, we can take a break and you can make copies of whatever it is that you need. Miss Anthony, did you prepare either Exhibit 4 or Exhibit 5?
I printed off whatever's in Christie's file. That's what I printed.
And that's marked Exhibit 5.
Correct.
Okay. Now, you started out and you said that you printed this from the program that y'all use.
That's correct.
Do you have access to that program today as we sit here?
No, I don't have my laptop with me.
Okay. Is that normally how you access the information?
I have a laptop and I have a desktop at work that I access it from, yes.
So that's the normal means that you use
Yeah.
to do it? Okay. Is there a reason why you didn't bring your laptop with you today?
I did not know that was needed.
it's not.
Okay. Well, I guess what I'm getting at is what is on the program that is not included in these files?
Nothing. Everything that's on the program that's Mr. Titta's is in this folder.
Is in that's been marked as Exhibit 5?
Correct.
Okay. All right. If you would open it up and let's see what's the first thing that's there in the file.
Legal invoice.
Okay. And
Legal invoices, you
Yes.
said? Please be able to keep your
Sorry.
voice up.
Legal invoices.
that first invoice does it have an invoice number and a date on it?
Yes, it does. Well, let's see, hold on. The date is August the 13th, and it has a statement number, yes.
August the 13th of this year?
2024.
Okay. And then what's the statement number on it?
149624.
And that's a bill from Dinkelspiel, Rasmussen, and Mink, correct?
Correct.
And who are they?
Answer the question.
The attorneys,
And the attorneys for Keith Collins or for the Arbors of Wedgewood?
the Arbors of Wedgewood.
Okay. And do you deal with that law firm on a daily basis?
I do.
Continuing
The-
relevance objection.
Does that law firm represent other homeowners associations that you represent?
Yes.
Does that law firm represent all the other homeowners associations that you represent?
Yes.
And how long has that arrangement been in place?
Since I've been here, so almost 3 years. But I'm not sure how long they've represented with Keith Collins. I can't answer that.
It's irrelevant.
Okay. Prior to Keith Collins managing the Arbors of Wedgewood, was there a management company that managed the Arbors?
I can't answer that. I don't know. Since January of 22 that I've been here, I've had them. But I don't know who they had before Keith Collins had them.
Okay. And well, the reason that I ask is that this case is about charges that were assessed by the Homeowners Association against the defendants.
Objective testimony by the lawyer.
Did that occur prior to? Well, I don't know. Answer my question. I mean, what is this lawsuit about?
Honestly, this started before I was employed.
That's what I'm getting at. So in other words, this started before you started managing the Arbors of Wedgewood, right?
That's correct.
And it was another management company? Or
No, it was another manager.
Another manager, okay. And you don't know who it was?
I know who she is, but she's no longer employed.
Okay. Well, who is it?
Christie Adcock.
Okay. And how do you know her?
I don't know her. She left Keith Collins about a month after I was there.
And so she had been assigned the Arbors of Wedgewood before you were?
Object to the form of the question.
You can answer.
Yes.
And do you know what she's doing now?
Object to the relevance of that question.
You can answer.
Yes, she's a nurse.
Unless I tell you don't answer a
Oh,
question,
okay.
answer all his questions, okay?
Okay.
I'm sorry, I
No,
didn't tell you
I
that.
don't know.
Yeah, unless I tell you not to answer all his questions.
Okay.
The objections that I make are reserved and, but you can answer.
I hear she's a nurse. I don't know that for 100% fact, but I know she was in nursing school when I started working here.
Okay. And I'm sorry, I've done this so much, and I assume other people are familiar with the process. I didn't ask you this, and I'm sorry. Have you ever given a deposition before?
No.
Okay. Well, basically what we're doing is I'm asking you questions. You answer to the best of your ability. If I ask you something you don't understand, just let me know, and I'll be happy to repeat it. And you have to speak audibly for the court reporter because she's taking everything down.
Okay.
And she'll yell at you if you don't.
Okay.
And you're doing fine so far. All right, so Christie Adcock was the manager for the Arbors of Wedgewood prior to your taking over the account.
Correct.
Okay. What date did you take over the Arbors of Wedgewood account?
January 4th, 2022.
Again, all of this is outside the scope of the 30B6 deposition, and if it goes on much longer, I am gonna stop and we'll call the judge and ask him whether or not we continue on it.
Okay. Now, is January 4th, 2022 also, didn't you testify that's when you first started with Keith Collins?
That's correct.
So Keith Collins was managing this association prior to your
Object to the
coming
form
on
of the
board?
question.
That's correct.
Okay. And it was Christie Adcock was the manager at that point.
That's correct.
And do you know how long she was the property manager before you?
I have no idea.
Okay. Would that be reflected in your records?
Yes. from the start of this was in 2018.
So you're referencing a letter, what is
A
that?
letter that she sent to Mr. Titta
And it's dated, is that September the 10th of 2018?
2018, and her name is signed, so that's, before that, I don't know, but I do know on September the 10th of 2018, she was.
Okay. And that particular letter, what is she sending a letter? What is it about?
Objection, the letter speaks for itself. It's in the file, it's been made an exhibit, and it's outside the scope of this conversation, of this deposition notice.
It says, please add mulch to beds immediately.
And that's mulch in the flower beds of the home?
That's correct.
And so is that part of association manager's job is to monitor the amount of mulch that is in flower beds in homes in the subdivision?
Yes, but normally the board, they send that information to us also. But we drive through periodically, try to monthly. But I can't say where this came from because I wasn't employed there, so I don't know.
I guess my question is mulch or lack thereof, is that a something that is regularly brought to homeowners' attention
Yes.
by your company?
Yes,
And so your testimony is part of your job is if a home does not have enough mulch in its flower beds, then you, on behalf of Keith Collins, send a letter to the homeowner requesting that they add mulch to the flower bed?
Object to the form of the question. It misstates, it mischaracterizes her testimony, and it is duplicative, asked and answered.
You can answer.
yes.
Okay. How many letters like that do you send out a year?
I can't answer that.
What about specifically for flower beds?
I mean, I can't give you a number, a lot.
It's a lot?
Yes.
Okay. Besides flower beds, are there other things that you send letters out to homeowners about?
Yes.
Like, give me an example. What other things do you do?
Cut their grass, junk in their front yard, stuff in the driveway. I mean, there's a lot of different things that we send letters for.
Okay. And then whose responsibility is it to then follow up on that and make sure that, I guess, whatever, I'm gonna say violation, is that what you would call that, is a violation? Or?
That's called a violation.
Okay.
It's my responsibility, but before I can send it over to the attorneys, I have to get permission from the board. I'm advised by the board, so I usually go through and I see what I need to send letters for, and I send them to the board, and then the board instructs me on how to handle it.
Okay. And what is typically, the first step, I guess, is to send a letter, correct?
That's correct.
Okay. And then after that, what would be the next step with the homeowner?
Usually I'll send a second letter, and depending on what the board says, I'll send a third letter or I send it to the attorney. It just depends on what the board says.
Okay. And how do you keep up with all of this?
It's in our program, Caliber.
Caliber? Okay. So it will remind you that you sent out a letter on this issue, and then it will tell you when you need to follow up?
That's correct.
Okay. Now, how does it do that? Does it do it on a calendar?
Yes.
Okay. Now, and did you print that out? Do we have printouts of that?
I printed out the violations that we've sent Mr. Titta.
Okay. And I guess let's keep going through those. So the first one you've got is September the 10th of 2018. This
Go
was,
to the form of the question, that's not how she testified.
okay. Well, let me ask you then, what was the first violation that you had from Mr. Tito?
September the 10th, 20.
Third letter.
Oh, this is the third letter, but that's how it is in Caliber, so I don't.
Well, go back, start at the beginning is what he wants. He wants the very first letter that was sent to Mr. Mr. Tito. So go back to the very first letter.
This is.
That
it.
is, okay,
Mhm.
all right.
I print down from start to finish
Okay.
in Caliber, and
All right.
that's.
I just said it was third letter.
Yeah, I know, I saw that too, but that's
Okay.
what I have.
Okay, well, so I'm clear now. Your testimony is, this is the first letter that you sent to the defendants, but on the letter itself at the top, in bold and underline, it says third letter.
Object to the form of the question. She didn't send it. She already testified that she didn't send it. So when you say you, either define you or
And let me
clarify your question.
let me clarify this for you. You're the 30B6 representative, and so all questions that I'm posing to you are questions to the association. And so you're answering on behalf of the association. You can have your own personal knowledge too, and unless you say that and say, this is my personal knowledge, this is not on behalf of the association, I'm going to assume that you're testifying on behalf of the association. Is that fair enough?
Objection. You're asking her to decide how to answer your question. You need to ask her if it's her personal knowledge or if it's on behalf of the association. I don't think you can put that burden on her.
That's the purpose of the notice and this whole exercise.
I
is what
understand
use.
that, but I don't think you can put that burden on her.
Okay. Well, that's the way we're going to do it. I'm going to assume that you're speaking on behalf of the association unless you tell me otherwise. Okay?
I can try to answer what I can.
Okay. So that letter, September the 10th, 2018, according to the program, was the first letter that was sent. What is the next letter that's been sent?
Yard work is necessary. Fines will be posted on account as stated below. That was November 2nd, 2018.
And what are the fines that are assessed?
$25.
And it says that they will be assessed to your account every 15 days that the violation has not been corrected, correct?
That's correct.
And who makes the decision as to whether or not a violation has been corrected or not?
The board.
And so part of your job is not to decide whether or not it's been remedied?
I don't add fines unless the board tells me to.
Okay. Now, this first letter, it says third letter, September 10, 2018. It says, please add mulch to beds immediately. Where in the restrictive covenants does it state that the homeowners association can control the amount of mulch that needs to be added to someone's yard?
We're gonna stop, and we're gonna contact the court, or you can move on to some other kind of conversation. Because this case is not based on mulch, fines, letters. It's based on a judgment that was taken against Mr. Tita I believe it was a default judgment, so we're not gonna relitigate whatever that judgment was. And this case is, this suit is about a foreclosure action on a judgment. It's not about mulch and declarations and covenants, so, either we move on or we can stop and approach the court. Whichever one you wanna do, Ben.
The judgment, are you familiar with the judgment that your attorney just explained, I guess, to us?
I'm familiar with it, but it was before I was employed.
Okay. So you don't know what that judgment was for?
No.
Who would know?
I'm not sure. I'm assuming the manager before,
Or maybe Bill Jolly.
maybe Bill Jolly, yeah.
And who is Bill Jolly?
He was the attorney for the HOA before DRM.
Okay. Now, the association has a president,
Okay,
correct?
stop. You need to answer my question. Are you gonna continue down this line of questioning? Because if you are, then we're gonna stop and we'll have to approach the court. If you wanna pass this and move on to something else, then we can reserve this question and move on.
Counsel, I noticed this deposition, and she has been designated as the corporate representative to testify about all these areas of inquiry. And one of the areas of inquiry was the fees and assessments that have been, and the billing and collection for the defendants in this case. And her testimony is that she can't answer the question. So I'm gonna clarify that. The duty is on is on you to produce a person that can answer questions in regards to all these areas of inquiry.
Okay. You are only entitled to do discovery on issues that are relevant to the case or that may lead to the discovery of relevant evidence. You are not entitled to discovery on things that are irrelevant. This case is based on a judgment that was entered back in 2021. It is not based on fees or assessments or anything else other than that judgment. And if you want to ask her about fees and adjustments and how they're done, I've been okay, even though I objected to it. If you want to ask her about the judgment is what the judgment is.
Well, my question is, what was the judgment for? What fees and what assessments was the judgment for? And if you want to get on the phone with the judge and we'll talk about that, that's fine.
Okay, we can do that.
Do you want to take a break and let's do that? Okay, we're going to go off the record. It is 9:52 a.m. Back on the record. It's 9:56 a.m.
Here. Hey, this is Robin Rasmussen and Ben Taylor. We are in the process of taking a deposition, and a dispute has arisen over the scope of that deposition. We need to speak with Judge Lundy at Chancellor Lundy about that.
Judge Lundy doesn't do anything by phone.
Okay. What do you want to do, Ben?
I'm ready to continue the deposition. You're the one that wanted to try and get the judge on the phone.
Thank you.
Goodbye.
Bye. Okay, well, we're not gonna answer any more questions outside the scope of this deposition. So if you wanna move on, I'm happy to move on. Otherwise, we can wait and I'll just file a motion and we'll get it heard. It's up to you.
Are you instructing the witness not to answer?
I'm telling you, we're not gonna do anything outside the scope, Ben.
Are you instructing?
She
the
can't
witness
answer, we already told you that.
Are you taking your lawyer's advice and not answering the question?
Object to the form of that question. She can answer what she knows, Ben, but we didn't provide somebody to answer questions going back to 2018, because that's outside the scope of your questioning.
Are you taking your lawyer's advice?
Yes.
Okay. One of the areas that we asked you to come in and testify is regarding witnesses, documents, and facts which support or may tend to evidence the merits of it, if any, of each assertion or plea contained in the plaintiff's complaint. And that's Exhibit 1.
She has the exhibits.
Do you have all of them there? It's number 4. See that?
Mhm.
And are you the best person to testify in
Where-
regards
where
to
we
that?
looking?
4.
Oh, okay.
I can answer what I know.
And I guess that's what I need to know is, are you the best person to answer questions about that? Or is there anybody else that would be better?
There's no one else.
Okay. Right before that, number 3, the truth vel non, which is Latin for or not. So the
Okay.
truth or not of the allegations of the complaint on file herein, and any basis in support or contradictory thereof, and the substance of the facts in support or contradictory thereof. Are you the best person to testify with regards to the complaint that's been filed in this case?
Yes.
Okay. We have trial set in 2 weeks. Do you intend to be the witness at the trial?
Yes.
Is there anyone else that could be designated as a witness on behalf of the plaintiff?
No.
Number 5, the procedures or policies and training employees and or agents of the association. Does Keith Collins have procedures and policies?
Yes.
Did you bring those with you today?
No.
Are they in a, I guess, are they kept bound in like a binder, or is it a book,
We have a handbook.
a handbook? Okay, what's it called?
Keith Collins Company Handbook.
Handbook. And is that something you're given as a new employee?
That's correct.
And did you bring that with you today?
No.
Okay, didn't want to interrupt you. Didn't want to interrupt you while you're asking your question, but the handbook is not relevant, nor is it reasonably calculated to lead to the discovery of any relevant information, which is why it's not provided.
Does that handbook, does it cover training and supervision and things like that?
Yes.
How big is this volume? How big is it? How many pages?
I have no idea.
Is it something that has changed since you worked at Keith Collins?
It's been updated
How many times has it been updated?
once.
Do
I
you-
think once.
Do you know what that update involved?
No, I don't.
And whose responsibility is it to do those updates?
Elliot Collins normally does the updates.
And who is Elliot Collins?
Keith's son,
Okay. And what's his position with the company?
vice president.
So he's vice president in charge of the procedures or policies and training employees or agents?
He's vice president of the company, so.
Okay. But if there's somebody that would be the best person to testify about training and supervision, it would be Elliot Collins?
I can't tell you.
Yes.
Okay. So number 5 and number 6, Elliot Collins is the best person for that. Going down to number 7, all procedures or policies in assessing and or performing and or effectuating the collection of fees and or payments, including but not limited to the specific transactions which are the subject of this lawsuit. Now, is it your testimony that you're the best person to testify on that, or would Mr. Collins be a better witness?
I would say myself, I would.
Okay, so number 7, you're the best person to testify on behalf of the association.
Yes.
Okay. And just going along here, number 8, all actions taken with respect to the collection of fees and or payments for the account which is the subject of this lawsuit and all other matters in connection therewith. Are you the best person to testify in regards to that area of
Yeah.
inquiry?
Yes.
And that's really kind of what we've been talking about going through these letters, is actions that are taken with respect to the collection of fees and or payments for the account, which is the subject of this lawsuit.
Objection.
If we could,
Hold on, let me get my objection out. You're not asking about, you haven't asked one question about what is the subject of this lawsuit. You have only asked about questions about what are the subject of a prior lawsuit, the judgment that was entered in this case. You're trying to go behind the judgment, which is not what this lawsuit is all about. This lawsuit is about a default judgment that was taken against Mr. Tita and the other defendant. You haven't asked one question about this lawsuit.
okay. The charges that were assessed prior to your coming on board with regards to the association, does your file reflect what those charges were for?
Objection, relevance if he's trying to go behind the judgment again.
Yes, they do.
Okay, and what are those charges?
Give him the paper that way. I'll hand it to him. For the record, Ms. Anthony has handed Mr. Taylor the ledgers with regard to this lawsuit that set out charges and payments, a copy of which is included in the documents provided to him labeled number 13.
So we're clear for the record, let's mark that as the next exhibit.
Okay, wait a minute, that came out of, that, let me go make a copy of it, because that, otherwise you're gonna split up something you already made an exhibit of.
Okay, so just so we're clear, this document's 3 pages, and it has an account number at the top right-hand corner, 118-300-5401, addressed to Tom and Sally Tita, 4916 Waterstone Drive, Olive Branch, Mississippi, 38654. And again, it's 3 pages.
Let me go make a copy of it so we can not destroy the exhibits that you've made. hold on, I want Mr. Taylor to confirm that I made the appropriate copies before he gives them to you, so he doesn't claim later on that they're not right.
I have no idea. I mean,
You just gave me the documents to copy. Are you now saying that those are not the documents?
is that what you're wanting me to do? You want me to authenticate them?
You just said you wanted to make them exhibits.
Okay, counsel. All right, let's mark this as the next exhibit.
Okay, let's put that back in your file. Which exhibit number is that?
This is exhibit 6. I always say. Exhibit 6.
Okay, this document that's been marked as Exhibit 6, how would you characterize that? How would you describe that document?
It's his ledger,
His,
Mr. Titta.
Okay, and is this, does this come from a program, an accounting program
It's in Caliber.
in Caliber? Okay. And does this reflect all the charges that have been assessed on this account?
Yes.
Hand you this document, ask you if you've seen that before.
No. If you would, on the third page of the documents that I just handed to you, and just for the record, this is a letter dated April the 23rd, 2024, from Dinkelspiel, Rasmussen, and Mink to myself regarding this case. And it includes, according to the letter, number one, an entire history of the homeowner transaction ledger. And number two, legal fees incurred as a result. Do you see that? I do.
Okay. Now, what is a homeowner transaction ledger?
What I gave you.
Okay, so what we previously marked as Exhibit 6.
Correct.
Okay. Let's go ahead and mark this as the next exhibit.
This would be exhibit 7.
So Anthony, if you would flip to the third page of Exhibit 7 and read for me what it says at the top. What is that document?
The top, the homeowner transaction history?
Yes,
Okay.
yes, ma'am. Is that what that is?
That's correct.
So what is the difference between the homeowner transaction history that is part of Exhibit 7 and Exhibit 6?
I mean, nothing.
Okay. Well, I guess the first thing, if you want to flip through it, if you look down at the bottom, it says page 1 of 31, correct?
That's correct.
And Exhibit 6 is 3 pages, correct?
That's correct.
So can you explain why one is 31 pages long and the other one is 3 pages long?
I can. I see there are reversals where I'm assuming the board approved to reverse a lot of these fines. So these reversals wouldn't reflect on what I print on their ledger
Okay.
because these fines were reversed.
Okay, and so you said that the association are the ones who reversed those?
Objection mischaracterizes her testimony.
Well, who reversed those?
The manager before me would have reversed them, but the board would have approved to have those reversed.
So that's Christie Adcock.
That's correct.
Okay. All right, and so just going through, and I guess let's start at the very top of this page. It has a posting date of 7/27/2018. It says final balance forward of $150. Do you know what that balance forward is for?
I'm pretty positive that is when they changed programs over to Caliber from, I believe it was called Skyline. And so I'm pretty sure that that's the balance that was forwarded over from the old program to the new program,
Okay.
which was $150.
Which was
$150.
Thank you.
But you don't know what that amount was for?
I do not.
Do you know who would know?
Our accounting department should probably have that information.
And you say our accounting, you mean the
Keith Collins.
Okay, so
Accounting.
Keith Collins or Arbors of Wedgewood?
Keith Collins, our accounting department,
Okay.
would have that information.
And the reason that it's not reflected on this is because this is the new program?
That's correct.
Okay. And who's in the head of the accounting department?
Objection irrelevant.
Who could tell us what that $150 is for?
Rebecca White.
Becca White, and she works at Keith Collins?
That's correct.
Okay, the next charge on there, or entry, is August the 2nd, 2018. It says a violation fine for shutters, $25. What is that for?
I can't answer that because I wasn't employed there then, so I'm assuming for shutters, but I don't know. That's what the record says.
Okay. Well, who would?
Objection irrelevant.
Who would know?
Christie Adcock was the manager then.
Okay. Is a violation fine for shutters, is that something you would normally send a letter for?
It's on each violation letter for Arbors of Wedgewood that I believe it states you have 15 days and then a fine will be assessed to your account every 15 days that the violation has not been corrected.
Okay. Now, so looking at the documents that you produced in this letter that we were talking about, September the 10th, 2018, and it's titled Third Letter. Is that for shutters or for mulch in the flower beds?
The letter says mulch in the flower bed.
Okay. But not for the shutters.
September the 10th, the letter is for the flower beds. the fine on September the 10th is for plant/landscaping and proper maintenance.
Okay. Now, so on September the 10th, 2018, a letter was sent to Mr. Tita regarding the mulch in the beds. And also on that date, charge was entered on his account for $25. Is that correct?
That's correct.
Now, is that typically what you do, is assess a fine along with the letter?
Like I said, I can't answer because I wasn't there, but I'm assuming that the third letter went out on that day, and that's why there was a fine, because of the second and the first letter. So every 15 days, there's a fine assessed to the account. But
Okay. Now, it looks like on September the 10th of 2018, there was a $25 fine. But then the next entry, also dated September the 10th, 2018, it looks like it was removed, or it was subtracted. Is that correct?
that's what it shows.
So who made the decision to reverse that charge on this account?
I can't answer that. I don't know.
You weren't there. Okay.
I wasn't there.
Okay. So going down, it looks like the next day on September the 11th, 2018, there was a improper maintenance fine of $25 assessed against the account. Is that correct?
Continuing objection as to the relevancy that has nothing to do with this case. And it appears to me that Mr. Taylor is proceeding in an improper way for the purpose of intimidating and harassing the witness.
Counsel, look, speaking objections, you state your objection,
I
and
just
then
did.
you can either instruct her not to answer, or you can be quiet and let me finish this deposition.
I just did.
Okay.
I made my objection.
Okay. All right, counsel.
Specifically designating the reasons for the objection,
Okay.
with no intent to provide her with an answer.
September the 11th, it was a $25 charge, and then on that same day, it was reversed. Did you see that?
I do, and I also see where it says fine not supposed to be assessed. So it looks like the system was adding and she went back and reversed them, is what it looks like, because this is every day.
Yeah, and that's what I was gonna ask you, is it looks like on the 12th, there was a $25 fine, on the 13th, there was a $25 fine, on the 14th, there was a $25 fine.
And they were
On
all
the
reversed.
15th, okay, and that's, I guess, to follow up on that, these dates, is that the date that they were reversed, or is, in other
Yes.
words, will the program reflect that, so in other words, this fine was entered and then it was reversed on the same day?
I mean, it's what it shows.
Okay. And so this was Mrs. Adcock, after getting authority from the association, was going in and reversing these charges?
I can't speak for what she did. I don't know.
Okay. Was Mrs. Adcock the account manager for the Arbors of Wedgewood with Keith Collins from 2018 to 2022 when you started?
That's correct.
Down at the bottom of this first page, September the 17th of 2018, there's a violation fine for shutters. Do you see that?
I do.
And is there a letter in your file that you produced as Exhibit 4 that references that violation?
No,
Do you know why?
I do not. Well, hold on. Actually, yes. Here's a letter for September the 18th. Please repair and paint shutters.
Okay. But that fine was reversed, right?
If that's what it says, yes.
Now, is this the same violation that was assessed the previous month for violation fine for shutters?
I mean, I can't answer that. I don't know.
And who can answer that?
Christie Adcock.
Going on to the second page, it looks like there are a number of $25 charges and then $25 reversals. And looks like it says the fine not supposed to be assessed. Do you know why that is? Why there were fines assessed that didn't need to be?
I can't answer that. I don't know.
Who would?
Christie Adcock.
The third page, it looks like there are charges from September the 23rd of 2018 to September the 29th of 2018. It's numerous $25 charges that were assessed and then reversed. And it's your testimony that Ms. Adcock is the only one that knows anything about that?
That's correct.
Same thing on page 4, the charges that were assessed from September the 29th of 2018 to October the 4th of 2018. These $25 charges that were assessed and then reversed. She would be the only one that would be able to testify to that?
That's correct.
Do you have any idea how this happened with this system, with the Caliber system?
I do not.
This Caliber system, is it set up to where it knows when it can assess fines, I guess every 15 days or so?
I can't speak for 2018, but today it's not. We have to go in and do that. But this was 2018, so I don't know how it was set up then.
Well, and I guess my question is, do you think that this is something that she's going in and assessing the fine and then reversing it as part of her job? or-
Objection, cause for speculation on the witness.
I don't know.
Is that something that you normally do with Keith Collins, is assess a fine on an account and then go back in and reverse it on a daily basis?
No.
So you would agree with me, this is not normal operating procedure for Keith Collins?
Object to the form of the question, cause for speculation of something that happened 5 years ago, 6 years ago.
I don't know.
So you don't know whether or not this is normal?
This isn't normal for today, no.
Okay, just flipping forward, it looks again like this is October of 2018. It looks like every day a fine of $25 is being assessed and then it's going in and being reversed. Is that accurate?
That's what it says.
Okay. And flipping on to page 6, this is still October. Shutters need repair or paint. There's a fine of $25 and then a reversal of that fine every day. Is that correct?
That's what the records say.
Okay. And flipping through page 7 says pretty much the same thing. Page 8, page 9, page 10, all the way up to page 11, which goes through November the 28th of 2018. Is that right?
That's correct.
And the only difference between all of those is it looks like a legal fee enforcement on November the 20th, 2018 for $160.23. Do you know what that was for?
I do not. No, I don't.
So your records that you have in front of you wouldn't reflect what that was for?
I can look and see. Hold on. Give me just a second.
Sure.
We've been going about an hour and a half, just whenever, can you take a short break? If you want.
We can take one now.
Whenever you want to.
Let's go off the record and let you review that. It's
That's what you're looking for.
10:28 a.m.
Isn't it? No.
Back on the record, it's 10:40 a.m. And I know we took a break for you to look and see about this charge. Were you able to find out what that was for?
Yes, it says postage, photocopies for setting up collection file and mailing demand letter.
And what's the date of that statement?
November the 16th, 2018.
And who is the statement from?
Graves, Smith, Palmertree, and Shaw.
And those are attorneys in Hernando?
That's correct.
And is that Mr. Jolly? It says timekeeper, W.H. Jolly.
That's correct.
And these were the attorneys that represented the association at that time?
That's correct.
And what is a demand letter by the attorneys?
I can't really answer that.
Who can answer that question?
An attorney?
Okay. Well, the association, you're hiring this attorney and you're paying them to do a job for you. So you're telling me that you don't know what he's doing that you're paying him for?
Objection argumentative.
I'm assuming his demand letter was demanding Mr. Titta to pay, but I've never seen this demand letter, so I can't speak for what his demand letter.
Is that normal for an attorney that is hired by the association to send letters and not provide you with a copy of the letter?
I don't remember how Bill Jolly did things. DRM, I do see the letters, but I don't know how I can't speak for Bill Jolly. Like I said, I wasn't employed then, so I don't know.
So what is DRM? Dinkelspiel,
Yes, I
Rasmussen?
was gonna say, help me pronounce.
Dinkelspiel, Rasmussen, and Mink.
And Mink. I always get the Mink part.
So your testimony is that you do receive copies of letters from the attorneys?
DRM, yes.
Now, we marked this as Exhibit 7. This is a letter dated April 23rd, 2024 from DRM with it says CC to client, which to me means carbon copy to client. But I think you testified you'd never seen this before.
What,
This is what's been marked as Exhibit 7.
let's see. I mean, if I did receive it, it's in a file or scanned into his, but I don't know.
Now, I thought your testimony was that you printed out everything that was in his file.
I don't have that, so no, I haven't seen that.
So is it your testimony that there are things that are in his file that we don't have here today?
Objection mischaracterizes her testimony.
I printed everything that I had that was in his file in Caliber.
Okay. But your testimony is that Exhibit 7 was not in your file?
No.
Now,
But your testimony is that Exhibit 7 was not in your file. Answer no. That could be debated. You want to restate the
Oh,
question?
excuse me.
Well, I'm sorry, I'm trying to keep the record straight.
Ma'am, your job is to write down what's said, not to correct him on how to answer,
I'm not
ask his
correcting
questions.
him, I'm watching out for the record, ma'am.
Well, this, I
Well,
think
here's
just,
my job.
we just wanna be clear here. So, I guess, is your testimony that you've never seen exhibit number 7?
Not that I recall.
Okay. And your testimony is that exhibit number 7 was not in caliber when you printed everything out?
No, this wouldn't be in caliber though.
Where
This
would,
came from the attorney.
okay, so where would it be?
It would be scanned into we call a file called public, but I don't.
And what is the file called public? What,
It's just where miscellaneous information goes.
miscellaneous information for each?
Just stuff that we use within the office. Nobody has access to that.
Okay.
It's just kind of for our own knowledge.
Okay, so is there a reason why it's not kept with the particular homeowner's file that you have?
No, I mean, I don't have this.
Okay. But-
Let me say this, I'm gonna instruct you to go back and look in the public file.
I'll have,
And if there is anything in there that pertains to Mr. Tito, we need to give it to Ben.
okay.
Okay, you agree to
Okay.
do that? You
I
have
will.
a problem doing that?
Yes.
Okay. And is that something you can do today?
Yeah.
Okay.
Let me ask you, can you call somebody, can you hold on a second, can you call Morgan and ask her to check that file? Because if she can do that and get it over us, then we can give it to Ben so that he can, include it in the deposition if he needs to.
Okay.
Can we do that,
Can
Ben?
you call
Sure.
now? Okay.
Cause that's something that we should,
Okay.
that's something that should have been in file 13, the document mark 13.
Do you want me to take down that conversation?
Sure, yeah, we're still rolling. Just so we're clear, who is it you're calling?
Morgan. Hey, can you, are you at your computer? Look in the public folder and under Arbors of Wedgewood and see if there is
Anything.
or anything, yeah, pertaining to Mr. Tito.
No,
There's nothing.
nothing in there.
Hey. What did you say? Okay,
Did you find
yeah,
something?
she found a couple of letters.
Okay, have her email them to me.
Email them to, Robin. Okay, thank you. All right, bye, she's sending them now.
Okay. I'm watching my email, I'll get them printed as soon as I get here. Okay, Ben,
Okay, so
I'm watching my email, she said there were a couple letters.
I guess where we left off, there was $160.23 charge from Mr. Jolly for a demand letter. And is it possible that the copy of that demand letter is in this public folder?
I'm not sure.
Do you know who would know?
Morgan's about to send what
Okay.
we have in there.
Okay. Now, do you still have Exhibit 7 in front of you? I think
Yes.
that's it, yes. Okay. So the charge from Mr. Jolly was, looks like, according to his statement, was done October the 18th of 2018.
His statement date's November 16th of 2018.
Yes, and then, but it looks like the day that he did the work was October the 18th, 2018, is that right?
Oh, yes. I see that.
Okay.
Sorry.
No, that's okay. And then it looks like that charge was reflected on his account on November the 20th, 2018. Is that right?
Those letters from Morgan are over. They just came through my email, so give me a couple minutes and I'll get them.
November the 20th, yes.
Would you ask
Right.
them to print the documents that was just sent to me
Yeah,
by Morgan
November 20th.
Hold on just a
on the
second.
ticket case and get 3 copies and bring them? Thank you.
Did you hear what your witness said, ma'am?
Mm-mm.
She said, those letters from Morgan are over, that's what you said, they just came through my email. And the witness said, November the 20th, yes, right, yeah, November 20th. And then Mr. Taylor said, hold on just a second till you came back in the room.
Okay.
You're getting those. Robin, is
They're
that
printing them
correct?
right now,
Okay,
yeah.
okay,
And Ann will bring them down in just a second, as soon as she gets them printed.
okay. Going back, on Exhibit 7 to October the 18th, 2018, the demand letter that was sent by Mr. Jolly, would it have been for the amount that was reflected on the balance here of $350?
Objection calls for speculation.
I don't know.
But your understanding is the demand letter would have been a demand for payment of money, correct?
Objection calls for speculation.
I mean, I don't know.
And according to your records, on October the 18th, 2018, what was, let me ask you that, on October the 18th, 2018, what was the balance due on Mr. Tita's account?
Looks like $350.
Okay. And there, looks like there were 3 entries on October the 18th. There were a charge for shutters need repair, $25, is that correct?
That's what it says.
And then a charge for $25 for plants, landscaping, improper maintenance, is that correct?
That's what the records say.
And then also on October the 18th, there's a reversal of $25 for the plants, landscaping. It says fine not supposed to be assessed, correct?
That's what it says, yes.
Okay. Is there a maximum amount of fines that you assess with the Homeowners Association?
I'm not really positive on, I don't know.
Let me, let's do this. We can flip to, the letters that are sent, the September 10th, 2018 letter.
Okay.
And flip to the second page. Is there a second page? Okay, and the third page? Yeah, the third page right there. What is that?
Yeah, the maximum of $200.
Okay, and so what is that? Could you read that off for
A
us?
$25 fine will be assessed for every 15 days that the violation has not been corrected, up to a maximum of $200.
Just to back up, this page that you're reading from, it says Keith S. Collins Company LLC, Association Management. That's your letterhead, right?
That's correct.
Okay, and then what does that say, that whole paragraph there?
Below that,
Right,
That's-
starting with please note.
please note that the Arbors of Wedgewood has a fine structure in place. First offense will receive a letter asking that the violation be corrected within 15 days. Noncompliance after 15 days will result in a letter asking for the violation be corrected immediately, along with the $25 fine. A $25 fine will be assessed for every 15 days that the violation has not been corrected, up to a maximum amount of $200. A second offense for the same violation within 6 months will receive a letter with fine structure assessed immediately.
And fine structure assessed immediately, what does that mean?
Immediately, a fine will be assessed immediately.
A fine of $25.
Right,
Okay, up to a maximum of $200, correct?
correct.
So, in any 12-month period, the maximum amount of fines that can be assessed for any particular violation is $400. Is that correct?
Yes,
Okay. And my question is, we're almost up to $400 for Mr. Tita's account here going through, and the fines that I see are for improper maintenance of landscaping and his shutters that need repair. Is that right?
that's correct.
And I guess my question to you is, how are we almost up to $400 and we're at October the 18th and,
Well, 160 of that was legal.
okay, well, I'm talking about before that. This is October. The legal fee didn't get assessed until November.
November, okay.
So October 18th, we're at, it looks like I don't know if it's 375 or 350 because there was a
It was
reversal.
a reversal.
Okay. And so, and these fines started the previous month in September of 2018. So it is.
There was a balance forwarded of 150. I don't know what that was for, so that's included in that also. The balance forwarded on 7/27.
Yes, and they're, looking at your exhibit number 6, if you'll look at that,
Okay.
the first statement, or the first date on that is January 1 of 2018.
Mm-hmm.
And it has previous balance, and it has a balance of 0, correct?
That's what it says. I don't,
So from January of 2018 until July of 2018, there was $150 put on this account, but it doesn't, the records don't reflect what that amount is for.
I'm gonna again note the irrelevant of all of this testimony for the last 2 hours and the objection thereto.
Is that right?
yeah, but I can't answer that because I don't know what it was for.
Okay.
I said earlier I could find that out with accounting.
Okay.
want to put your stuff down and join us so you can hear what's going on this case? We're going all the way back to 2018. Note for the record, Mr. McNary just entered the office, and he is objected to it, but, and then this is forever.
All right, going through Exhibit 7, and just so we're clear, have you ever seen this 31-page transaction summary ledger for this account?
No.
What is the difference between this transaction ledger and then the ledger that you provided as Exhibit 6?
Objection, asked and answered.
Other than one is 3 pages and the other one's 31 pages.
Objection, asked and answered.
You can answer.
Okay. This I printed from his ledger on his account. It doesn't show reversals. This would have had to have been pulled from a different place in
Okay,
Caliber.
clarify your pronouns.
This
Exhibit 6.
Exhibit 6 is pulled directly from his ledger.
And,
So it
and
does,
when you pull it and you're saying ledger, so is that what it's called, as ledger?
from
Okay.
his account summary.
Okay, so that's an account summary.
That's correct.
And on Caliber, is there a homeowner transaction history?
Yes.
Okay, and the difference between the two is that the history includes fines that have been reversed.
It breaks everything down.
Breaks everything down, okay. So you do have access to this transaction history, you just didn't print this out?
Correct.
Okay. There's other charges on here, or I guess payments that are referenced, lockbox payment. What is that?
Where are you seeing this?
This is on page 16 of 31. It's January the 25th, 2019.
Sorry, I didn't realize we'd
2019.
hopped that far.
2009.
What date did you say?
This is January the 25th of 2019.
That's where he paid his annual assessment.
And what's a lockbox? What is that?
I mean, I don't know what exactly lockbox mean, but that's where I guess that went to his account.
So I guess my question is, did he pay in cash? Did he pay with a check? How
We
did-
don't accept cash. He would have paid either by check or on the portal. I don't know. I wasn't there. I didn't start until 2022, but I know we've never accepted cash. So
Okay.
it had to be check, money order, or the portal.
Okay. And when you receive a check,
Mm-hmm.
are you the one that's responsible for making that deposit?
No,
Who does that?
accounting.
And you said Rebecca White.
That's correct.
Okay. And is she the one who enters the payment so it's reflected on the account?
Yes.
Going forward, looks like on page 25, these are entries from November the 29th, 2019 to December the 22nd of 2019.
What page did you say start on?
Page 25.
Okay. Okay,
It looks like these are charges for plants and landscaping, general yard maintenance. Is that correct?
that's what the record says.
And those are charges $25 every day. Is that correct?
That's what it shows.
And that's not according to the guidelines of the association, is it?
The guidelines say every 15 days.
And that $25 is assessed every 15 days, not every day.
Correct.
So you agree that these entries are in error on the system?
Yes.
Now, when you send statements, or I'm assuming that you do you send statements to homeowners that reflect what their balances are?
Yes.
And if someone has an issue with their statement, who would they talk to?
Morgan or myself.
Your testimony, though, is that you can't explain why these assessments are being charged every day on the system.
No, I wasn't employed in 2019, so I can't.
But you agree with me they were not supposed to be.
Object to the
can't-
form of that question, mischaracterizes the statement, and it mischaracterizes her prior testimony.
You can answer the question.
I mean, I don't know. I don't know why. I don't know.
But you don't know whether it should have been done or not? I mean, does it comply with your policies and procedures or not?
I would say no. It should not have been daily, but I mean, I don't know why it's like that.
Okay.
Page 25. All this stuff is wrong.
Okay. Now, at some point, Mr. Jolly was hired to file a lawsuit in justice court against Mr. Tita. Is that correct?
Hold on 1 second. Ben, here are those letters that were just delivered. I don't know if you wanna include them in file 13 in her file, or if you wanna do them separately. I'm not sure how you wanna do that. I just wanna make sure that you have them all.
Let's do it separately. We'll mark these as the next exhibit.
Okay, and these are gonna be 8.
Yes, ma'am. Exhibit 8
Okay.
are the aforementioned
That
letters.
was your stuff. Well, here, I'll hold on to it, because she's gonna.
Yeah.
There were some more letters that were in the separate file that Christie didn't.
What is that?
It was a
Did it
stamp.
get pulled out on an exhibit?
I don't think this was marked as an exhibit. This was a.
Did we mark Jolly's? I don't think we did, because I didn't go make a separate copy of it. You don't want to?
It was just there loose, so I just wanted to make
It
sure
was
it
part of
wasn't part of
her,
another
her
exhibit.
file, which is also included in the
Oh, it
folder
was in your
marked.
file? Then put it back in your file, please, ma'am,
And,
because that is an exhibit.
and just to assist you to keep it organized, if you'll put it right in front of the September 10th, 2018 letter, then it'll be exactly where it was.
I thought it was in the.
I thought it was in the front.
It was in
too.
the collection of legal.
It's in the back in my copy, and so that's why I'm trying to help you with it.
I mean, you're jumping all over the place, so I can't keep up.
Yeah, I'm sorry.
No,
should have noticed that in your file. You should probably keep the other exhibits maybe in the middle of the table in your file, that way if you move something over, you won't lose
So it
it.
would be right here. Okay.
There we go.
Okay. I just wanted to just understand what was happening.
And for everybody in the room, I'm just trying to protect the record. I don't know anybody in this room. I'm not anybody, nobody's my regular client.
If you're gonna talk, you need to record what you're saying, okay?
Whatever you want me to do, ma'am, I'm happy to do.
Okay.
The lawsuit that was filed in Justice Court. Do you know when that was filed?
No.
Who at the association would know the answer to that question?
Christie Adcock.
Are you familiar with the lawsuit that's been filed in this case?
Not really, no.
Well, you know, that's one of the areas of inquiry that we set out.
This has been going on for a long time, so I don't,
Well, I'm talking about the complaint that was filed July the 29th, 2022.
I'm handing her a copy of the complaint, if that's okay with you. For the record, I've handed Ms. Anthony a copy of the complaint filed.
you wait, I mean,
Yes, ma'am.
okay, yes, I am aware of this.
Okay. And when the date this lawsuit was filed, what did Mr. Tita owe the association?
I'm not really sure where I would find that. I'm showing on my records on 7/25. Oh wait, this was, I'm sorry, never mind, scratch that. Let's see, 7/25.
It's listed on the exhibit. There's an exhibit attached to the complaint.
I'm sorry, I can't hear you, do you want this on the record?
I said, is there an exhibit attached to the complaint? It's the judgment. That's what's owed.
Which was,
Well,
But I can't, I'm sorry. Oh, here it
the
is.
judgment was 1,160.
That was an exhibit to the complaint.
and what is that?
It was 1,165 was the judgment.
What is that you're looking at specifically?
The judgment
Okay, and the judgment from who?
from
Justice Court?
Justice, yeah, Justice.
Justice Court.
So
And what was the amount?
$1,165.46, either 46 or 40 cents. I can't read.
Okay, so the $1,165.46 was a default judgment that was entered against the defendants in Justice Court, correct?
Correct.
And that's what was owed by the defendants on the day that you filed this lawsuit?
Ask me that question again.
Okay, and just to clarify, on July the 29th, 2022, you signed a verified complaint
That's correct.
for judicial foreclosure of homeowners association liens and for damages
Correct.
against the defendants. And my question is, what is the amount of money that you're claiming you're entitled to and that you're seeking to foreclose on this man's home in order to recover?
The records say $1,165.46.
Okay, now, you said the records. Are you referring to the judgment, or are you referring to the ledger that we've been talking about that is marked as Exhibit 7?
I'm talking about the judgment.
Okay. Now, according to the ledger, on the day that this complaint was filed, July 29th, 2022, what was the balance on the account?
I don't have I have the balance as of 8/3 on this account.
Okay, and what is that?
$3,279.92.
And what document are you referring to? What exhibit?
Exhibit 6.
Okay. And that date again is 8/3/2022?
That's correct.
Okay. Now, if you would, flip to Exhibit 7 and look at that same date. I'll just tell you it's the last page.
Okay.
And what is the amount?
What date was that? I said 8.
August the 3rd, 2022.
$3,365.15.
Why are those amounts different?
Let's see. And I can't answer that. I don't know.
Who could answer that question?
I'm not. Sure.
But you agree with me, they're different figures, right?
They are.
Is that normal?
No. I don't know why they don't match.
Can you explain why your complaint is for $1,000 and change, but yet your records reflect over $3,000 is due on a day?
Well, attorney fees, I guess, is why it's different.
So the attorney fees were $2,000 to file the verified complaint?
I don't know. I mean,
Objection mischaracterizes her testimony.
You can answer if you can.
I don't know. I have legal statements, but I mean, I can't answer that.
Do you know who could answer that question?
No.
Well, you agree with me, that's probably something we need to get to the bottom of, since you're suing these people and trying to take their home, and you can't give me a straight answer on what is owed.
Object
Is
to
that
the
right?
object to the commentary, object to the form of the question, argumentative, asked and answered.
Is that right?
I'm not suing these people and trying to take their home. The HOA is suing these people trying to take their home.
Okay. And does the HOA, is this something that the HOA has done before?
Not since I've been here, no.
Now, this is Arbors of Wedgewood.
That's
What
correct.
about the other associations that you represent? Have they
Objection.
filed
Hold
verified
on.
claims to foreclose on people's homes when you said yourself you don't even know how much he really owes?
Objection to the form of the question, objection to relevancy of the question, and if you know,
Counsel,
you
I'll
can
give you a
answer.
continuing objection on relevance. You don't have to state that anymore.
I'm not gonna answer to what my other associations do because I
No,
don't.
you gotta answer it.
I don't know.
You can't refuse to answer, okay? You
I mean,
gotta-
I've done foreclosures, yes. It's never gone to actually, well, actually, I take that back. I think one was just taken, but they're home. But yes, I mean, I have done this before.
Whose home are you talking about?
Objection, relevance.
I can't sit here and say, I don't know.
You don't know offhand the name?
I do not.
Does Keith Collins manage the association for Brayburn Homeowners Association, Inc.?
We do not.
Do you know who does?
I do not. I believe it's right, but I'm not 100%.
I believe it is.
Right management, but I'm not 100%.
What about the Estates of Southern Trails Homeowners Association?
It does not sound familiar.
You're here on behalf of the association. Was the association advised that this was the proper way to go about collecting these fees from the defendants?
I don't understand what you're asking me.
How did the association decide to bring a suit to foreclose on this home when you've already got a judgment? Why did the association not just try to collect the judgment?
I'm advised by the board, and the board decided this. I think there has been attempts to collect on this.
And you were just handed something by your attorney. What is that?
You're welcome to give it to Mr. Taylor. I mean, that's part of the court's file, so he should have that. But
Yes, ma'am. This is perfect for us to go over. Let's mark these as the next collective exhibit.
Let me go make a good copy of that before you mark it. Do you mind, Ben?
It's up to
It's the only one,
court
it's the only copy we have, so.
Pages.
Okay.
But
Do you mind?
Be happy. Is that good enough?
Yeah, if it's good enough for you, then.
Thank you.
It's the
Yeah.
only copy I have, that's why I wanna
I
make it.
understand,
And it's a part of the, court's record as well.
yeah. Lord. She's a fireball. You said this was usually your yoga day?
Yoga pants day.
I bet you wish you were in them.
Yeah. I normally don't, if they even see me in the office on Fridays, it's normally half a day. We've had meetings every night this week. We're gonna get home till 9 o'clock, so. Yeah.
Thank you, ma'am. It's hard to keep if we don't give it to you clipped, or isn't it? There you go.
All right, some of that was part of my file and not part of the John file, if that matters to you.
Well, it's part of the record now, so.
Okay.
All right,
So
exhibit number.
let me make sure you have a complete copy, so that you will have everything that's in there. All right, here you go.
Wait a minute before we start adding stuff too.
No,
This-
I didn't add anything. This is exactly what you made as an exhibit. And I just wanted you to have a copy of it. It should be 11 pages. And it includes my notes as well as that you wanted to make part of the record. Here's a,
Thank you.
This is gonna be exhibit number,
That was no,
9.
okay.
Okay, Ms. Anthony.
I'm ready.
Okay, yes, Exhibit 9, looking at that, this is a declaration that was filed in Justice Court. It says that the defendant is indebted to the plaintiff in the amount of $1,080.46. Is that right?
That's what it says.
Okay. And looking at exhibit number 7 on page 30, in January of 2021, this is January the 27th, 2021, how much was owed on this account, on Mr. Tita's account?
$1,005.46.
Now, that's not $1,080.46, is it?
No.
Okay. And that's actually, that amount is what was the balance on January the 1st. On January the 19th, there was a payment that was received of $160, right?
That's correct.
So according to your records, on January the 19th of 21, the balance on the account was $845.46. Is that correct?
Yes.
Okay. And can you explain then why you filed suit for $1,080.46?
No, I wasn't, I wasn't employed then, so I can't say.
Do you agree with me that the balance on the account on January the 27th, 21 was not $1,080.46?
That's correct.
And do you know who could explain that?
Christie Adcock was the manager then.
No. Now, you received payments from Mr. Tita on this account at one point, did you not?
There shows payments on his account. I don't know what you're asking me.
Okay, well, what payments does it show?
Objection, scope and time.
And there was a payment, 1/19/21. There was a payment, 1/19/2022. There was a payment 1/19/2023. 3/28/2023.
And all of those payments were for $160, correct?
There was one on 4/28/2023.
You need to answer.
Yes,
Okay. And $160 is the yearly dues for this association, right?
correct,
So the Titas have always paid their dues every year, is that correct?
correct.
Okay. All right, I think you stopped at April 28th, 23.
April 28th, 2023, there was a payment for $1,100.
Now, do you know where that payment came from?
I have no idea. It came from Mr. Tita to DRM.
You say from Mr. Tita to DRM.
That's correct.
So it's your testimony that he sent the check to DRM?
I'm assuming he sent the check to DRM. I mean, it came to DRM. I'm assuming he sent the money.
So your testimony is that he didn't send that money to the association?
objection mischaracterizes her testimony.
Well, what is your testimony?
He sent a check, it says right here.
And what are you referencing? What are you looking at?
Let's see.
Is that what exhibit? Let's start there. Is that exhibit 7?
Page 31 of 31. It says on 4/28, payment received, DRM, 500.93 for $1,100.
Okay. And that is April the 28th of 2023.
Correct.
Okay. And you said DRM 50093. Does that mean that that check came from DRM?
Yeah, he sent the check to DRM, and
And then DRM sent the check?
and then they send the money to us, which we put it into add it to his ledger.
Who is us? Keith Collins?
Keith
or-
Collins, yes.
Okay. So your testimony is the association never received that money?
I don't know what you're asking me.
I'm asking you, on April the 28th, 23, you have a credit on his account of $1,100, and you're telling me that it was from DRM. Is that right?
Mr. Titta sent the money to DRM.
How do you know that? How do you know
I
that?
don't know, I'm just looking at the records.
Okay. But according to your records, that DRM is $1,100 from DRM that was credited to the account?
Yes, we turned him over to DRM, so everything comes through the attorney and then comes to us, to Keith Collins.
So a homeowner wouldn't send something directly to the homeowners association?
Not if they've been turned over to the attorneys, they would send it through the attorney's office.
So your testimony is that that's the way it always happens, that the association never receives funds directly from a homeowner?
Object to the form of the question. That's not what she said.
Well, then what did you say?
I said, when a homeowner is turned over to the attorneys, all payments go through the attorney's office. So he would send the money to DRM, and then DRM sends the money to us at the end of the month. Any money they've collected comes to Keith Collins.
Okay. In your file, do you have any letters from Mr. Tita?
From him?
Yes, ma'am.
No, I haven't had any communication with him. Not that
Look through the file before you say that.
I don't.
Wasn't there a letter that went with this?
Mhm.
Doesn't that go with that?
That does.
Yeah, I think.
I know it does.
Okay.
That was put in,
That was the one where we never got it. Okay.
correct.
Okay, what are we talking about? What?
Okay, in your file labeled number 13, I think you
Just
just.
let her testify.
Oh, I'm
too.
sorry, I thought you were,
No, I'm talking to the witness.
sorry,
What
my bad, I'll shut up.
are we talking about?
This is a letter that was put in each board of directors mailbox from Mr. Titta.
Okay? And what's it dated?
It's not.
It's not dated October
Oh, wait, I'm sorry,
21st?
October 21st. Yes, I see that, I'm sorry.
2022? And
Mhm.
it's a letter, and then there's a copy of a check as well. Is that
That's correct.
Let's mark that as a next exhibit.
Thank you.
Mhm.
Can you give me a staple? I mean, paperclip. This is exhibit 10. You don't have any fan-ins, do you?
I don't, I buy them.
Okay, 2-page document. You got one.
Okay, this letter that's been marked as Exhibit 10, you seen that before?
Yes.
Okay, and I believe your testimony was that a copy of it was put in each person's mailbox?
The board of directors.
And who are the board of directors of Arbors of Wedgewood?
One, Lauren, Brian Cope, Angela Hawkins.
Okay, and Juan Lauren, is he the current president?
He is
Okay, how long has he been president?
3 years, maybe.
Do you know if there's a reason why he's not here today to testify regarding this?
I do not.
Does he know about this lawsuit?
He does.
And he's authorized this lawsuit.
Yes.
Is he aware of the discrepancies in the totals that we've pointed out so far?
Objection, she cannot testify as to what someone else is aware of.
I don't know.
Okay. Vice President Brian Cope,
Correct.
is he still vice president?
He is.
And how long has he been vice president?
I'm not sure.
And Angela Hawkins, the treasurer,
Correct.
how long has she been the treasurer?
I don't know.
Is she still the treasurer now?
She is.
And this letter is from Thomas and Sally Tita, right?
Correct.
And the letter talks about they've been homeowners in this neighborhood for 15 years and that they had a problem with landscape design. Is that right?
That's what it says.
Are you aware of what the problem was with the landscape design?
No, this was before my time.
Okay. It says that they're due paying members and they've never defaulted. Is that true?
From from what I've seen on the records, yes, that's correct.
And the fines, it says in the letter that they disputed these fines that they were sued for in justice court, but they've decided to make full payment of $1,165.46 to Arbors of Wedgewood HOA and attached a check. Is that right?
Yes.
And that's what the second page is. It's a check from First South Financial payable to the Homeowners Association of Arbors of Wedgewood for $1,165.46. Is that right?
That's correct.
And is this the money that was credited to the account that we were discussing earlier?
That's a different amount. I think it was 1,100 though.
And that's precisely why I'm asking you the question. The account was credited from DRM $1,100, but the check that was sent was for $1,165.46. And I guess my question is, what happened to the $65.46?
I can't answer that. I don't know.
But you agree with me, it was not accurately reflected on his account, and he wasn't given full credit for that payment, was he?
Objection, mischaracterizes her testimony.
This was 10/20 of 22. I don't see any payments received until April 28th of 2023.
Exactly, and that's the critical issue and the question that I have in this case, is why he sent y'all a check for over $1,000 on a judgment, and instead of crediting it to his account and bringing it down, y'all filed a verified complaint for foreclosure to foreclose on his home.
Objection, that mischaracterizes her testimony and the complaint.
And that's
That's
okay,
all
you-
I'm gonna say.
That's
but-
all you need to say. You
That's
don't
all
need
I'm
to
gonna
say
say.
anything else.
Except that you're trying to mislead the court on the dates.
I'm not trying to mislead anybody, and I take exception to that.
Well, then maybe you ought to
No,
look at
don't,
the
hey,
dates.
you don't need to state anything else, counsel. So you can't explain this, why he sent a check in October of 22 for 1165.46, and his account didn't get credited until April of 23, and it wasn't credited for the full amount. There's money missing, right?
Object to the form of that question, assumes facts not in evidence.
Am I right?
I mean, I can't answer that because what I'm seeing here and then here, it's different, but I don't.
That's what I'm asking.
I can't answer that, I don't know.
But you agree with me, it is different,
The amounts are different, yes.
and that's not usual in your business, is it?
No,
You understand that when this complaint was filed, counsel had you sign an affidavit verifying the veracity of the allegations in the complaint that were filed. Were you aware of that?
yes,
And were you aware of this discrepancy when you signed that paperwork?
no,
You agree with me, it's not accurate. Correct?
I mean, yes.
Okay. Have you spoken with either the treasurer, the president, or the vice president about this check and this letter?
No.
How did you know where the letters were put?
Yes, I did actually. They told me that these were put in mailboxes, but that was all. Actually, I was on a chain in an email. They were talking amongst each other, so I just kind of follow, just read along.
Okay.
They communicate in this group email, and I just,
Now, the group email, is that a normal means of communication?
yes,
Did you bring those emails with you today?
no.
Why not?
I don't know. I just didn't.
Okay.
Can you
Counsel,
get those emails and give them to Ben?
Yeah,
is that part of the program that you use, or is it a separate program?
no, it's a separate
Okay, what is this?
Outlook.
Outlook? Yeah, let's do this. Can we take a break and let you contact whoever you need to talk to, and let's see what we have to do? Is this gonna be a voluminous amount of communications?
No, I don't think so, no.
Okay, well, let's see if we can get those, and we'll take a break, go off the record. It is 11:48 a.m. All right, we're gonna go back on the record. It's
Let's go back on the record.
11:53.
Was your GoPro running that whole time, Ben?
It was not, but it's back on. I keep a time dialogue. It's 11:53, we're back on. And so,
I'm gonna renew my objection to this particular court reporter. I have asked her not to comment on testimony. She believes that she's entitled to do that. She has also instructed me about how I conduct the defense and told me not to not to interrupt because it makes her job harder. It is clear to me that this court reporter is biased and that she is not acting in compliance with the rules of her profession. And I have asked for a new court reporter, which of course has been declined.
this is absurd. No, you haven't asked for a new court reporter. You just said that, and I haven't declined anything. The court reporter that is here is certified and is an officer of the court, and she's doing her job. I am here. I'm a certified officer of the court. I'm doing my job. And hopefully, so are you. And so I don't know what, I think your issue was with her clarifying something on the record, and that's, my position is, that's her job. And as far as bias or anything like that, I've been sitting here thinking about it. I do not believe that I've ever used this court reporter before for anything. She was, I believe, a former federal court reporter in North Mississippi with Judge Biggers. Don't believe anybody in my firm has ever used her before. And this is the first time she's ever heard of this case, and it's the first time she's ever met me. So I don't understand why you think she's biased, but if we could, Ms.
What-
Anthony, were you able to talk with somebody about these emails?
Yes, she sent them to Robin.
Okay. Mr. Rasmussen, is that it? Are you looking now for those?
Yes.
Okay.
I will have Ann print them. That's okay with you? Can we get? I'm gonna have to look at these because some of them are from my firm. I think those are subject to attorney-client privilege. Krista. What's that date? What?
I'm looking at the date.
Yeah, I'm just looking to make sure that. Okay, I'll have these printed, except for the ones that are between my firm. Otherwise, I'll have them printed. Is Ann still here?
Yeah.
Okay, would you ask her, tell her that there's a bunch of emails coming through, with regard to Mr. Tita, and I need those printed and brought to me, please.
Rob, can I move forward?
Sure.
Okay.
Sorry.
No, that's okay. The complaint that was filed for judicial foreclosure, is it your understanding that the house will be sold on the courthouse steps to the highest bidder? Is that the way you understand it to work?
Yes.
And what do you think would be a reasonable amount for this particular home? What do you think its value is?
I don't know. I don't know the values of those homes in there.
Okay. Well, who would at the association?
The board, the homeowners.
But you can't answer that question.
I mean, I would say,
Objection, speculation.
yeah. I mean, I don't. $300,000 to $400,000. I don't know.
Okay. Would you agree with me that if the home goes to the courthouse steps, that if it ended up selling for, say, $15,000, that would be egregious, would it not?
Objection calls for speculation. And she's not qualified to answer that question. She's not an expert.
You can answer.
So I answer?
Yeah,
Mhm.
you can.
Okay.
Unless I tell you not to
Okay.
answer.
Yes,
Do you agree with me? That would be egregious.
yes.
Okay. Were you aware that, that DRM has done this with other homes in DeSoto County, the judicial foreclosure?
Same objection.
Yes,
And do you know if they were successful or not?
I'm not sure.
In Chancery Court, DeSoto County, cause number 23-CV-1329. It's Brayburn Homeowners Association versus Tony Peace, Tina Stores, and Maddie Stores. Looks like the Homeowners Association, represented by DRM, filed a complaint for judicial foreclosure and got a default judgment, basically, and sold a home in Brayburn subdivision through judicial foreclosure. Were you aware of that? Do you know where Brayburn Homeowners Association?
I used to manage it, yes.
Those homes are nice homes, would you agree?
I mean, to some standards, yes.
Would you agree that most of those homes are worth at least $200,000?
Probably, yes.
Objection, relevance.
In this particular case, it was sold for roughly $15,000. Were you aware of that?
No.
And the court went back and entered an order setting aside that foreclosure and found that the judgment was the result of that it was a void judgment and allowed the relief from the judgment for fraud, misrepresentation, or other misconduct of an adverse party. Did you know that?
No.
Objection mischaracterizes the order and what happened. And relevance.
The attorney fees that have been incurred so far pursuing this, do you know what the total amount is so far?
No, I don't.
Who would know that?
I guess the attorneys would.
I think really that's precisely the point here. It's troubling for me that the association doesn't know what's owed on this account, but yet you want to foreclose on this guy's house. And it's like the fox guarding the hen house. The person who is doing all this is the law firm that's constantly billing and increasing the balance on this account.
Objection.
Is that
there's-
troubling to you as the association?
Objection assumes facts not in evidence.
You can answer.
I mean, I don't really understand what you're asking me.
What I'm asking you is that if this was you and this was your house, and you had a homeowners association that was sending you bills that didn't make sense, and that even they can't explain what the bills are for, would you have a problem with them not only going and getting judgments against you, but then filing a complaint to have your house foreclosed on over $25 fees that should have never been assessed and that are questionable?
Objection, hypothetical, not speculation, irrelevant.
You can answer.
Yes,
So you would have a problem with that?
yes.
recently, the Arbors of Wedgewood sent out a letter to all the homeowners regarding the yearly fees. Are you familiar with that?
What letter are you referring to? So I'm sure it came from my office.
I have a copy of it. Let me make sure.
Yes.
Objection, relevance.
You recognize that letter?
Yes.
Mark that as an exhibit.
This will be exhibit 11. Two pages. There you go, ma'am.
Can you explain the purpose of that letter?
Objection, the letter speaks for itself.
You can answer.
Okay. They are trying to raise their dues, their yearly dues, and do a special assessment,
Who is they?
the board.
Okay. And why are they doing that?
Raising their dues?
Yes, ma'am.
Because 160 a year is just not enough to cover what they pay a year. Insurance, common ground,
Legal fees?
legal, I mean, just everything.
And
And the
I guess
spec-
my question is, the legal fees in this particular case, were they the reason why this letter was sent?
No.
I think you testified earlier, you don't know what the total legal fees are.
I don't, but there's, the reason for this, here is that, well, the special assessment, there's a fence down, and it's been repaired, but it needs to be replaced, and the cost was like $80,000, and there's not enough money to do that. And then $160 a year that each homeowner pays is not enough for stuff that comes up, because, I mean, they've never gone up on their dues in the 20-something years.
This letter that Mr. Tita sent along with his check, it's Exhibit 10, where he paid the $1,165.46. If the association has received this money from him, again, why have you filed a lawsuit to foreclose on his home when he paid the judgment?
Objection assumes, mischaracterizes the testimony, assumes facts not in evidence.
You can answer.
I wasn't aware that the payment for the judgment had been paid.
You agree with me, the fact that it has been paid changes everything here, right?
Objection mischaracterizes the testimony, assumes facts not in evidence. Come in, Ann.
You can answer.
I mean, if it was paid, then
Not
yes. But it doesn't show on my records that it was paid. So I mean, I see this check, but my records don't reflect this check.
Your records don't reflect the $1,165.40, but it does reflect $1,100 that was, I guess, received from DRM.
Like 10 months later, I think, yeah.
And you can't explain that.
No.
Let's do this. Let's go ahead and take a break for lunch. It's 12:10. We're gonna go off the record. Okay, it is 1:19 PM. We're reconvening the deposition. And I think that we're having some copies of emails made that you were able to get. I want to go back, if you would you look at your copy of Exhibit 7.
That's the big one.
Yeah.
And go to the last page of that exhibit. Can you identify that last page?
No.
What does it say at the top?
Tab 3, client ledger report. Dinkelspiel, Rasmussen, and
I'm
Mink.
sorry, what'd you say?
Dinkelspiel,
Rasmussen.
Rasmussen, yeah, and Mink.
Rasmussen and Mink.
Rasmussen and Mink.
Have you ever seen that document before?
No.
Okay. Looking at it, it looks like the first charge that is on there looks like July 19th, 2022. Do you see that charge?
Sure, we're looking at the same one. Nope, that's not the same one.
Yes, I see that.
And the total, it's for, the bill total is $1,434.60. You see that?
I do.
And after that, it looks like there are other, looks like fees and charges, and it looks like that some of them were paid. And the question that I have is that invoice or the statement for that first line item, it's statement number 115359. Do you see that?
I do.
If you'll go down to March the 28th of 23, you'll see a payment of $1,434.60, and it says apply to statement number 115359. Do you see that?
I do.
Why did the association wait, it looks like 11 months to pay the first invoice for the work on this particular account?
I can't answer that. I don't know.
Well, let me ask you this.
Come in.
On these collection accounts, do you pay your attorneys a contingency fee or a percentage? In other words, is there being paid to collect on these accounts contingent on their success, or are they paid no matter what?
No, the HOA pays, and then when money's collected from the homeowners, the HOA is reimbursed.
And I guess that's why I have that question, is why did the HOA not pay the first charges on this account for almost a year till after they were incurred?
I'm not sure. I mean, I pay them as they come in.
So you're the one that's responsible for that. You get the
I
invoices
get
from
the
that
invoice.
firm?
I get the invoice and I enter it into the computer and then send it to accounts payable. Accounts payable pays. They cut the checks.
And accounts payable is with the homeowners association? or-
Keith Collins.
Okay. So wait a minute. So does the homeowners association control their own bank account?
No, that's why they have a management company.
So the management company controls all the money?
Well, I mean, we keep the records and stuff, but we don't do anything. I mean, the financials are sent out monthly. We don't make any decisions without the board advising us.
That's not what I said, though.
Okay.
I guess what I'm saying is that Keith Collins, all the money that comes in and goes out, they're the ones that control those accounts?
We don't control anything. We keep the money, we pay the bills, we do as we're advised by the board.
Okay. So, well, you're here on behalf of the Homeowners Association. And I guess my question is, why did the Homeowners Association not pay that bill?
I can't answer that. I pay the bills as they come in to me, so I don't know.
Well, who can? Somebody had to have made that decision. You agree with that, right?
Object to the form of that question.
I'm not agreeing to anything. I don't know.
Okay. Well, the purpose of this exercise is for me to get information.
Okay,
For me
but
to ask somebody who knows.
I don't
Somebody
know, but I
knows-
don't know.
But you agree with me, somebody does know that, right?
No, I mean, I can look through the statements and see what date it was sent to me on, but I can't explain why it was sent to me in March instead of July. I can't answer that.
Okay. Well, it looks like that there were balances due for additional work in between that time period. Do you see that?
I do.
And it looks like those were paid, right?
Continuing relevancy objection.
Yes, I see that.
And so you see what I'm saying? I guess my question is, why?
I do,
did-
but I can't answer why it was paid in March instead of July. I don't know. I pay them as I receive them.
And I guess my question is there an agreement with the law firm that they won't collect on these until they receive money from the homeowner?
Objection asked and answered.
You can.
I mean,
answer
I don't
again.
understand what you're asking me. I told you the process of how we do it.
Right.
The
This is what-
HOA pays the attorney fees, and then once it's collected from the homeowners, the HOA is reimbursed, but the HOA pays it up front.
Part of your job managing this homeowners association is to watch over the money and make sure it's not misspent, right?
Yes.
And I guess my question is, who's making the decision to run up over $5,000 in attorney fees on an account where the amount of money being sought has already been paid?
Object to the form of that question, assumes facts not in evidence.
The board.
Okay. And so who on the board is making those decisions?
All three of them.
Okay. I know we talked about.
Four of them now. Sorry, there's four of them now, but,
Okay, who's the fourth one?
I can't think of her name right offhand.
Do you know what?
She's new. She's new.
Do you know what her title is?
I'm not even sure. Juan's the president. Angela's the treasurer.
Brian is the vice
Brian is
president?
the VP, and I can't think of what her name is or what her. What it-
Secretary?
No, I don't know.
Okay.
Is it Jessica?
Jessica, yes.
Okay. Jessica Rowe?
Yes.
Okay. And how long has she been, did you say secretary, or do you know if that's what
It's,
she is?
She's just been on a few months. Maybe 6, 7, 8 months.
Part of our notice asked that you bring the financials for the homeowners association. Do you have those?
Pretty sure I've objected to that. Let me make that objection now. Which number is that?
Just so we're clear, you're making these objections now, and this notice has been filed for over a month. You know, in fact, the request for reduction was more than 30 days ago. And you didn't object, and so, but I guess you didn't bring any financials or any documents like that?
No.
Okay.
Let me look at one of those exhibits that Ben put in. Hold on. I'm taking exhibit 9. And for the record, the reason I've got exhibit 9 is because that, oh, here we go. I'm giving it back to you. Exhibit 9 included my notes, which I pointed out, but Ben wanted them in there anyway, so. Financial. Is that any and all accounting records of the plaintiff? Is that what you're talking about, Ben? Paragraph 27?
Looks like that covers it, but I think that there's other, I think it's also requested in other.
Okay, so 27 is a specific objection as being irrelevant, except as to TITA, which is provided in the folder number 13 that we gave you. The accounting records of the HOA is not relevant to any of the discussions here. And it's overly broad and unduly burdensome. Let's see, what else did you have? Anywhere else? Let me check to make sure that's not someplace else. Just so we're all covered. Okay, so it's not in your first list, and I don't see it in your second list.
Did you bring the
No.
financial documents?
No.
Okay. Do you remember me
No,
a couple of weeks ago?
no.
Okay. At the meeting that y'all called at the church for raising the rates? You don't
For
remember me
Arbors?
sitting out in the audience?
No.
Okay, I was there. I don't remember you either, but.
I was there, but
I
there was
assumed that
so
you
many
were.
there, I don't.
Exactly, there were lots of people there.
Mhm.
You remember, I think a lot of the homeowners were wanting that exact information. They wanted to see the books and see what the balance was,
Mhm.
right?
Mhm.
You remember that?
I do. And
And-
they were
and-
told that there is a portal, and the financials are on there the 10th of every month. And they all have access to that same portal.
What
And
portal
information.
is that?
It's the Keith Collins portal.
Okay, and, I mean, is there a reason why, I guess you say we can access it on this portal, but you're not gonna bring it to the deposition here today for us to look at?
I mean, I wasn't aware that I needed to.
Well, it's in the request for production.
Well, I have someone sending me the financials now, if we need them.
Now, do you also remember at the meeting that there was a discrepancy in the account balance? That I think one homeowner asked, well, how much money do we have in the bank? And there was an answer given, and then later on, it was told, well, wait a minute, no, we don't have, it's a different amount. Remember that?
Not really.
Okay. You agree with me, a homeowner that is a member of this association has a right to see all that stuff, right?
Yeah, it's in the portal. Any of them can log in and see at any given time.
Except when we come to a deposition where you're suing the homeowner, y'all don't wanna bring it then.
It's not
Is that
relevant.
the
for
reason
this-
why?
No?
Objection, relevancy.
Okay. Did the members of the board at that meeting advise the homeowners in this association how much money had been spent on this particular case?
Objection, relevancy.
I don't recall that. Brandon ran that meeting. That was a special meeting.
Don't you think they should? Do you think the homeowners would want to know that all this money has been run up in attorney fees on a case that never should have been filed to begin with?
Objection, argumentative, and irrelevant.
You can answer.
We don't really discuss, we don't discuss with the homeowners about his case. I don't.
Okay, well, that's not what I asked you, though.
Okay, well, what are you asking?
Well, what I'm asking you is, don't you think that's information that the homeowners would need to know at a meeting, especially when you're asking to double their yearly assessment, that maybe the reason you don't have the money is you have lawyers filing lawsuits that should have never been filed and running up legal fees that the association is paying? They're not waiting to see if there's a collection and then paying the lawyer. They're going ahead and paying these fees as they're accrued.
Objection, relevancy, asked and answered, assumes facts not in evidence, argumentative.
You can answer.
I have answered that. They can see this information on the portal. The financials are the financials, and they're on the portal. They come out the 10th of every month.
How much this year have you spent on
I
attorney
have
fees?
no idea.
Who does know that answer?
I can get that information.
Okay, well,
It's in our system.
I asked for you to bring it here today, and
It's
so
not relevant.
It doesn't. Can you bring me the information or not?
Objection, relevancy.
Counsel, I've already told you, you can have a continuing objection to relevancy. You need to stop interrupting the questioning and let me get to the bottom of this.
Objection, relevancy.
How much money have you spent on attorneys so far this year?
How much money has the board spent on attorney fees? I'm checking that for you. I don't spend any of their money. The board spends the money on legal fees.
Okay.
I'm advised and I do what the board tells me to do.
Okay. You provided me with a copy of emails that have gone back and forth. And there was one email in particular from, I believe it was the president. And it is an email from Juan Carlos Lauren dated Saturday, June the 4th, 2022, to Christie Anthony, to Angela Hawkins, and to Cope Family Bills. And then it also has copies going to Timothy Rowe and Nicholas Naylor. Who's Nicholas Naylor?
I'm not sure who Nicholas Naylor is.
Okay.
He must have been on the board at that time.
Okay.
What was the date again?
June
This
2022.
is June 4th, 2022.
I'm trying to find it. Yeah. Got August, September. June the 4th, I got June the 8th, June the 6th, oh, here we go, June the 4th. Christie, Angela, Cope, Jessica, Nicholas Naylor. Brooke Crabtree, is that included? Is that the one? Where it says, it starts with, please note more history on the case? Is that the one we're looking at?
Yeah, it starts out, Christie, please see below, more
Gotcha.
history on this case. It
Okay.
goes back to March 2021.
Gotcha. Okay.
Okay.
You see that?
Yeah.
And it looks like it's from Mr. Lauren, who is the president, asking for a comprehensive report from the attorney's office that provides status and all the history of this and all the cases that are open in our behalf. Filings, court days, actions taken, results, next steps. We also need to know what are the probabilities of recovery of all collections in 2022. We see a lot of legal fees charged to us, but not results or follow-ups whatsoever. Due to the Michael Hatcher's surprise huge increase in our 2022 contract and the high number of delinquencies, we are close to negative $7,000 under the 2022 approved budget. And looking at the latest report, if we don't recover any of the monies owed to the HOA, we will have to tap into the reserve account in order to be able to finish the year. And this is something we want to avoid. At the same time, we would like to schedule an in-person meeting at your offices to talk this and other urgent concerns. We'd like to have KC leadership representative and a representative from the legal department or the attorney's office who is in charge of our cases. Best days for us are Tuesdays and Thursdays. Please advise Juan Lauren, President, AOW HOA. And do you remember getting that email?
I mean, that's been two years ago, no, but
Do you know if a comprehensive report was prepared that provided a status and a history of all of these cases?
I mean, I'm sure at that time, I think that's when Jolly had it. So that would have come from Bill Jolly.
Okay, so that's, and you say that's in June of 2022?
And I feel like DRM got involved shortly after that,
Okay,
Maybe shortly before that.
or for shortly before that, yeah.
yeah.
Because I had just started that January, and that was June, so, yeah. We parted ways with Bill Jolly not long after I started there.
Now, did Mr. Jolly, did he handle other accounts for Keith Collins?
He used to, yes.
And I guess did Keith Collins, when you split ways with Mr. Jolly for the Arbors of Wedgewood, did you split ways for him on other homeowners associations as well?
Yes.
And how did that go about?
What do you mean, how did that go about?
Well, I mean, why did you pick DRM?
I have a relationship with DRM and I moved everything to them.
And you did that for all the homeowners associations that you manage?
Yes.
And did you get permission from all those boards and advise them why you were switching attorneys?
Yes.
And why was that?
We were just moving everything from, because Bill Jolly, we weren't seeing results that we felt like we should have been seeing in a timely manner, so we moved everything to DRM.
And that wasn't just in regards to the Arbors of Wedgewood Homeowners Association. That was in regards to all the other homeowners associations that you were managing with them as well, right?
That's correct, along with I'm pretty sure our companies moved everything to DRM minus maybe one or two associations.
Prior to that was Mr. Jolly representing all the homeowners associations that Keith Collins managed?
I can't say that for sure.
Okay.
I don't know.
Look, we've got 3 copies of these emails. Can we go ahead and just mark one set of these? I guess the
Sure.
set that she has is the next exhibit.
Let me put them back together. Which one is this?
12.
Did you send them to your email?
You can if you want to. I'll get her to print them. Well, hold on a second.
I didn't hear what y'all said.
I'm thinking about this. Yeah, go ahead and print them. Here's my concern. I don't want them to be a matter of public record. So if we're gonna make it an exhibit, then I'm not gonna, well, I guess, yeah, bring them and we'll give them to him, and I'll just have to file a motion to seal it if he tries to file them. Because I don't think that's appropriate. And I do think they're irrelevant, but whatever.
I had Joyce send.
Send them to me.
Well, I'm forwarding them to you. She sent me
Okay.
2018 to today.
Okay. And hey, would you ask Ann to print the financials that are coming over? What are there, 6 of them?
18 to 24.
18,
so
18,
to today.
yeah.
Yeah.
There should be 6 of them. Yeah, thank you.
Just so I'm clear, exactly what is it that is getting sent?
The financials that you wanted to see.
Okay, and what is that, what is it comprised of? Are these balance sheets, are these ledgers, what exactly is it?
It's everything to do with their financials.
Hold on,
And
let me see if I can.
Their financials, are they maintained on this system that y'all use?
That's correct.
I forget the name of it, what is it?
Caliber.
Caliber, okay. So with Caliber, are you able to print checks?
That would be an accounting question. I don't print checks, no.
Do you wanna look at this until they bring the actual ones? No, okay.
Also, in our notice, we asked for any and all minutes of all official meetings of the Homeowners Association. Do you have those documents with you today?
Objection irrelevant. Go ahead.
Since I've been there, we have never met quorum, so there's never really been an official meeting, so no minutes were taken.
Okay. What about meetings with just the board of directors? There's no record of those meetings?
I don't meet with the board of directors. We don't have, they don't have meetings.
Okay. Well, and I guess what I'm
And
getting
it's
at.
the secretary to keep the meetings and send them to me, and I don't have any minutes, and I don't have any minutes, no.
Well, I guess what I'm getting at is, when you say that the board makes these decisions, typically a board will make a decision and they document it through minutes. Right, I mean, are you familiar with
No,
that?
yeah, but that's not required, no. They just vote on it. They don't have minutes, no.
So there's no record of these votes?
Of votes for, as far as TIDA goes?
For anything?
Yeah, there's votes, there's emails.
Okay, and how do you keep up with the votes?
I mean, as I get the votes, then they're in a folder, they're in the folder. I mean, I'm not really sure what you're asking me,
Yeah, well, where are they? We requested those.
I
then-
brought everything involving TIDA's case.
Okay,
That was all sent, and she printed.
okay, but I'm talking about just for this nonprofit, the Arbors of Wedgewood, the minutes and the corporate records,
Like I said,
do
I don't
those
have,
exist or not?
I don't have any minutes because quorum hasn't been met, so if quorum's not met, then we don't keep minutes, and that's the secretary. That's not my job to keep the minutes, that's the secretary's job to keep the minutes. But if if quorum's not met, it's not really an official meeting.
But there's no record of that meeting and the fact that there was not a quorum?
There's a letter that we send out notifying the homeowners of the meeting.
But not notifying them of what the result of the meeting was?
No.
And is that typical?
Yes.
So all the other homeowners associations that you manage, they pretty much don't have any minutes either?
Object to the form of the question and the relevancy.
If they meet quorum, yes. If they do not meet quorum, then no.
Okay. But your testimony today is that you didn't bring any with you because they don't exist?
My testimony today is if we did not meet quorum, no minutes have to be, there's no minutes taken. So then therefore I have no minutes. And since 2022, Arbors of Wedgewood has never met quorum.
Okay. Looking at this exhibit number 7, again, the last page. Well, strike that. The second to last page, page 31 of 31.
Okay.
There's a notation there, a reversal of a fee, legal fee, and it says remove per Tony at DRM. Who is Tony?
He is an employee of DRM.
What's Tony's last name?
Carrier.
What is his job at DRM?
He's Brandon's paralegal in collections, I think.
He's the head of the
He's the head of collection team, yeah.
And what is the collection team?
Collect the money. When we send the homeowners over to collections, he collects.
Oh, okay, so for delinquent accounts.
Right.
Okay. Or for aggressive collection, right?
Right.
You're using
Objection.
an attorney to do it, right? You're not just sending out a bill yourself.
I don't understand what you're asking.
Would you agree with me that sending an invoice from the association to a homeowner for a fee in the mail is seeking to collect it and then sending to an attorney to collect, the attorney, that's a little bit more aggressive attempt at collection, right?
Yes, I send 3 before it ever goes to an attorney.
You send 3 what?
Statements.
Okay. And what do those statements look like?
I mean, I don't have a statement with me.
See, I'm
Look
not-
in your file.
Do you have any statements that were sent to Mr. Tita?
Yeah, I'm sure.
What-
No, with me, a statement looks like this.
Okay.
This
And
is a statement.
is that what has been sent to him?
Once he was turned over to the attorneys, I can't send anything to him
Okay. And why is that?
because that's what I've been told.
Okay.
Not to do.
Okay. What is that?
I can't see that. What are we
I
looking
can't
at?
see it either. I'm not real sure.
Oh, what does it say? What does it look like?
I mean, I can't say, but it kind of looks like what their due, like what they send out for their dues every year. But I'm not sure, because they got a due date January 1st. So I guess that's for, their annual dues, but I'm not sure why it's 56.
You're not sure why?
Okay,
what?
so, yeah, see, it's showing previous balance, but we bill for the 160 every year. So it's just pulling his previous balance, and then we're asking for him to pay his annual dues, the 160.
So then, what is this document?
It's like a coupon book.
a coupon book.
I mean, I don't really know it comes from accounting, it's a statement.
Okay, comes from accounting. What is accounting?
What is accounting?
Yeah, you said it comes from accounting.
It comes from our accounting department that sends out statements to collect dues.
So you're saying our, are you meaning
It comes
Keith?
from Keith Collins, yes.
Oh, okay. So Keith Collins does send these out,
Yeah, we send them to all of our homeowners every year.
and you do that on behalf of the association.
Yes,
Now, do you have those here?
No.
All the ones that you sent to Mr. Tita?
no,
Why not?
because I don't.
I've requested all of that in this discovery deposition. That's the purpose of this, is to get your copies of
Well, I
things
don't
like
have
this.
Mr.
This is
Chief,
my only copy, so could,
You want me to make you some copies?
well, I'll tell you what, that's fine.
I'm
Let's just,
happy to do that. for
let's
you.
just mark this as the next exhibit.
I mean,
Okay,
isn't-
that's gonna be exhibit 13.
okay, I think that is exhibit A to the complaint, I think. Let me look at my. Exhibit A.
No, you're fine.
Complaint. 1, 2, exhibit A. Oh, that was an exhibit to Mr. Tita's affidavit, filed as document number
I'm not ready
6.
yet.
Okay, sorry.
Okay, now I'm ready, go ahead now. That was exhibit,
That was exhibit A to Mr. Tita's deposition, Mr. Tita's affidavit filed August 21st, 2023 as document number 16 in this complaint. So that actually came from Mr. Tita.
Now, well, wait just a minute, counsel, and that's not accurate at all. If you're gonna sit here and you're gonna testify, then you do need to be sworn. This did not come, she just testified that this comes from the Homeowners Association and from Keith Collins. You can sit here and try and create whatever record or state, you wanna call me, say I'm misstating facts.
That is exhibit A.
Listen, just counsel, okay, let me finish this deposition, because I'm pretty much done anyway at this point. You don't have the financials that we requested, and you don't have any more of these statements like that are marked for exhibit 13 that came from your company.
The financials I just emailed.
Yeah, they're printing those as we speak.
Okay, we can make those exhibit 14, and exhibit 13, we have that statement, but you don't have any of the other ones that were sent to him.
No.
Now, at exhibit 13, what's the total amount owed?
$5,688.77.
Okay, let's look at your statement, look at your records, and tell me what's the date on that statement?
The date on this statement?
Yes, ma'am.
January 1st, 2023.
Okay, on January 1st, 2023, according to your records, how much is the balance on
Which
Mr. Tita's
record?
account?
Which record are we looking at then?
I'm asking you to look at your records.
What, are you referring to a particular exhibit?
No, ma'am, I would like for the company, I would like for you to tell me, according to your records, how much did he owe on that date?
On here, January 1st says $6,053.54.
And what are you looking at? What document are you looking at there?
This ledger
The
that I
ledger?
printed out and brought.
And that is exhibit number 6, right?
Yes.
Why are the figures different?
I have no idea.
Do you know who will know the answer to that question?
I do not.
But you agree with me, they're different amounts.
Objection, asked and answered.
You can answer.
Can I look for a second before
Sure.
I answer? Yeah, they're different. I don't know why.
And
Come in.
do you know who does know the answer to that question?
I do not.
Do you need a copy?
No, do you need more?
Not right now.
I'm waiting.
No,
on-
I already answered your question. I said,
Okay.
I don't know.
And you don't know?
No.
Who would know the answer to that question?
No.
Okay.
So for the record, I'm handing Mr. Taylor financial reporting packages for 2018 through 2024. I would note that all of these documents are available to Mr. Taylor's client through the portal that all the homeowners have access to, so he could have gotten these documents at any time. And I think he's gonna make those Exhibit 14.
Yes.
Mark those next.
Do we have a rubber band by chance?
Yes. I can get one.
I'm sorry, I don't
That's all
have
right.
one with me.
Can you bring me a rubber band big enough to put a bunch of documents around?
I
Thank
just
you.
know how it is, they all get, you don't watch, they all
Oh,
can
sure.
get
I
loose,
don't
and
think I have any in
it's
here.
a big mess. And then people take them home with them too, if I don't want to. They don't mean to, you know, you just fold up a cover and it's gone.
I'm sure when you run out of hundred.
Sure.
Yeah.
You're gonna get a rubber band, just so we can keep it together. Thank you,
Yes, give them to that
ma'am.
lady.
Appreciate it. There you go. I handed them to her. Did you need one?
Oh, yeah, I would love to see them, yeah.
I'm sorry. There you go.
Thank you. Who is Lisa Porter?
I have no idea.
It's got down, it says controller, CPA.
Never heard the name.
It's got email address lporter@keithcollinsco.com. Is that the email address for the company, that this keithcollinsco.com?
Yeah, but I don't know who that is. That was way before my time. I've never heard her name.
Do you know who prepared these documents?
Who prepared them?
Yes,
They're
ma'am.
in Caliber.
Okay.
And
Well-
our accounts payable sends them out every month.
Okay, well, I don't mean to confuse you, okay? The first page of the documents, Exhibit 14 that you handed me, says financial reporting package, Arbors of Wedgewood, number 792, from December the 1st of 2018 to December 31st of 2018. And it says prepared by Lisa Porter, Controller, CPA.
I don't know. I can't answer that. I don't know who Lisa Porter is.
Okay. So you don't know whether she prepared these or not?
I've never heard that name.
And you don't know who did prepare these?
I don't know, I've never heard her name.
But again, my question is, you don't know who prepared these?
Objection asked and answered.
I don't know who Lisa Porter is.
Well, on the first page, 12/1 to 12/31/18, it says prepared by Lisa Porter.
Okay.
The next one says financial reporting package, 12/1/19 to 12/31/19, but it doesn't have a prepared by on the front of it. Do you see that?
Yeah. I
So
do.
so when I ask you, do you know who prepared this? I'm not saying her, I'm saying, do you know who the person is that prepared this document? Do you have a name?
I did not start working there until 2022,
Okay.
so no, I do not.
Who would know at,
Christie Adcock.
okay. All right. Here is the ones for December of 2022. Do you know who prepared these?
It's in Caliber. I mean, they sent out what's entered in the computer, what comes in, what goes out, and the computer generates it.
Who is they?
Accounts payable sends it out every month.
And that's accounts payable at Keith Collins
That's
Associates.
correct.
Okay.
On the 10th of every month.
So is your testimony somebody at Keith Collins prepares these documents?
The computer, she just sends, but everything's inputted in the computer, and the computer generates it, and she sends it out to the homeowners and to the boards, and I'm copied on it.
Okay. Yeah. Going through these documents, is there a summary for the different contractors? So like, say, attorney fees, how much was paid in a given time period?
There should be.
Please note for the record that Ms. Anthony does not have those documents in front of her.
Okay, no, so I'm looking, okay, this is her copy. Did we get a copy made of these, or is there just one?
Copy of mine.
Oh, okay, okay. Okay, so we're clear for the record, and I'll hand these documents back to you so we can go through them and make sure. But this first set of documents that has the exhibit number on it is the package December 1, 2018 to December 31, 2018. And it looks like all it has is December of 2018 transactions. Is that accurate?
That's what it says.
Well, flip through it and see if you see any other transactions other than December in any of that.
That's the check register. Let me see. For the whole association? Okay. So that- Looks like it's just for the month of December. There's that
Mhm.
number. Oh, no,
Oh, she sent it, so, cause it's December, cause it's the whole year, year to date, yeah.
the year-to-date numbers.
Mhm. Yeah,
Okay, so let's see what we have here.
she sent that, cause it shows that's for the year. These are all for the year, yeah. December.
Yeah,
Mhm.
so what was the question again?
Well, it doesn't, it looks like this is just information for the month of December for 2018.
December, it shows for the year, year to date, so that's why she sent December being the last month of the year, and it shows, like, homeowners fees, we collected for the year 17,507.
Okay? But it also shows checks. It has a check register report. And it's only for the month of December. So is that the only month that
No,
that the
that-
association writes checks, is in December?
No, she sent, what page? What are you looking at?
Well, I'm actually looking at it. I'm looking at
She sent
2019.
December because it shows for the whole year. I mean, the year, like the amount that we collected, the amount, late fees, legal reimbursement, collection fee, and it shows the year, it's for the year.
Okay, and what is it that you're looking, what's at the very top? Describe what you're looking at there.
Arbors of Wedgewood, 792, Homeowners Association income statement.
It's the income statement. Okay.
Correct.
And does it have the expense statement along with it?
Yeah,
Okay. And is that, your testimony is that that's for the entire year?
that's correct.
Okay. There's a general ledger report in there as well?
Okay, go ahead. Oh.
Okay.
And so it's your testimony that that's for the entire year? Or just for the month of December?
I hesitate to open my mouth, but you had a question on the table.
Can you read it back?
And ma'am, that is not improper, that is totally proper for me to say that. Okay, there's a general ledger report in there as well.
That's what I was flipping to, yes.
And your testimony is that that is for the entire year?
The-
The balance shows, I'm sorry.
No, you're fine. The general ledger report, let's see, management fee. So that's for the month of December, see it, 300.
Right,
But the balance,
That's
yeah,
the balance, but it doesn't give the transactions for all the other months. So in other words, what y'all provided is this from December the 1st until December 31st of the years 2018, 2019, 2020, 2021, 2022, 2023,
Well,
2024.
see what they say.
We would like to have all the other 11 months of each one of those years.
Can I see those?
Do you want me to get Joyce to send?
No, I do not. think all of this stuff is irrelevant. I think we've given you.
Counsel, I just asked you to produce it, and you've already made your objection to it. We marked this as an exhibit. There are months missing from all of this, correct? This is just December of each one of these years, correct?
I wouldn't say that's correct, because the first few reports, it's for the year.
Okay.
The
I'm not
general
talking about what the
leg-
running balance is. Of course, at the end of the year, if you look at the running balance, it's gonna have that. I'm talking about for transactions. So transactions in the month of January for any of these years are not reflected in these documents, are they?
No.
Okay. I've just got one last question, and then I'm gonna adjourn this deposition, because all this information should have already been provided and produced.
I think I get to cross.
My last question is this, before I adjourn, and then we take this up with the court, is insurance. Do the board of directors have officer and chairman liability insurance?
They do.
Who is that? Who's the company?
I don't think it's on that.
That's outside the scope of the questions
I mean,
anyway, so.
I can't tell you exactly who it is
But-
right off, but yes, they have.
But the board is insured
Yes, the directors and officers and general liability.
for
yes.
errors and omissions and
Yes.
general liability?
Yes.
Okay. Do you know if you are insured with Keith Collins? Do you have any kind of E&O policy that protects you?
I'm sure Keith has insurance, yes.
But you don't know.
I mean, yes, Keith Collins has insurance.
Is that something that the board requires of any management company that is going to manage the collection and payment and basically, totally control all the financials of their nonprofit?
Keith requires the neighborhoods to have general liability and D&O insurance.
I understand that, but
Okay.
do the homeowners in turn require Mr. Collins to have E&O?
I've never been asked that question, but I mean, I don't,
Well, I mean, you're managing the money for all these associations. They've never said, hey, do y'all have insurance in case, something happens?
no, but I mean, Keith has insurance. I'm sure that's a given, but no, I've never been asked that question.
Okay. So we're in adjournment.
I think I have some questions for her. that I believe I'm entitled to answer or ask.
I haven't completed.
not correct?
I haven't completed the deposition yet, so.
Well, today's the day.
No, it's not. Today was the day, and I don't even have the right person. I mean, just so we're clear and we're on the record, you called me yesterday and wanted to continue this, and you said that you didn't have the right representative. So was
And
Ms.
you
Anthony,
insisted
was
on
she
going-
the person that you intended, or is she someone new?
She is one of the people that I intended.
Who are the others?
You refused
So you
to go
knew that you
forward.
could have had others. Who were
Not
the
today.
other witnesses? Well, then who are they? Who are the other witnesses that were not available today that you?
I'm not under oath, and I'm not gonna answer
Well, I
that
think
question
when
because
we take it up with the court,
we
you're
can.
gonna need to respond to it.
Well, you can do that, but Ben, I told
You
you.
have an obligation to
You
produce
said you were going
witnesses.
forward with this deposition, and
'Cause
I
it's
said I
court
would
ordered.
have the people here.
Because it's court
And
ordered.
I have the person here that can
You have
answer
one person.
the questions that were relevant to this lawsuit. You have yet to ask a single question that is relevant to this
I
lawsuit.
think that you owe, it's incumbent on the deponent to produce witnesses that can testify in the area of inquiry. And
Which we
there
have
were-
done.
No, she actually testified she couldn't answer half the questions that I asked.
Because they were irrelevant and not,
No,
and
that's not
outside the
why.
scope.
She said she didn't know. She didn't
And they
know.
were outside the
She
scope.
didn't know.
She didn't have to know, Ben. We only have to produce the person that can answer the questions in your deposition.
Okay.
In your
And-
notice.
And you're saying that you've done that?
I have.
Okay.
Anything that was relevant and appropriate, she did. She was here to testify
We're gonna
to.
take this up with the court. accordingly. That's all in this
Here, let's
deposition.
put that here. Oh, wait a minute. No, I'll get a
Okay,
copy of that.
is electronic copy okay with you guys?
Yeah,
Is that
that's
okay
fine.
with you, Mel? Okay, that was easy. That was the easiest question all day. Everybody-
And, oh, wait a minute, let's go back on the record, please.
Hang on just a second then, because I already,
Sorry.
let me see if it'll say, if it'll take it or if I gotta come back in. Yep, it's gonna make me come back in, sorry.
It's okay.
These machines are fast. Okay, hang on. I have to say, yes, we're pending. Yes, ma'am.
I need a copy of the videotape deposition that Mr. Taylor took as well.